Hi, y'all. Good morning.
Good morning.
I'm just looking here, taking a little bit of roll while I see people jump on. So don't mind me because we got a couple of minutes. Or we're 1 minute over, actually. But I'm going to wait just a few minutes to see. So 1, 2, 3, 4, 5, 6, 7, 8, 9 we have 9 people. Excuse me, signed up this morning, and I only have 3 logged in so far. So,
And there's 2 of us with me.
okay, great. Who's me? I'm sorry, I didn't see who was.
No, I know.
Karina,
Sorry.
gotcha.
We're Christina and Karina Perez.
Gotcha. Andrew, I don't have him on the list, but he might be a different name. Andrew, hun, I see you logged in. Did you sign up with the law library, or are you just jumping in from a link somewhere else or somebody else's name, hun? There's an Andrew Shalaby.
That's actually Sonia Dunn Ruiz.
Gotcha. Okay, perfect.
Yeah.
It's all good. Got you. And then so I have 4 of 9 on. So I'm gonna give it 2 more minutes if y'all are okay with that, just so nobody misses any of the beginning.
Yes.
See, yeah, none of the bottom people. We don't have anybody who is really preferred except for Tamara. Sorry.
Carolyn Taylor's preferred.
But she's not on.
She'll be here.
Y'all have your coffee and donuts going? Don't mind me, I got bagels.
We're working on the coffee right now.
Right, there you go. I just heated mine, so yes, I'm right there with you. Although I have to be careful with Rex. Last meeting, he accidentally dumped his whole copy on my papers.
Oops.
A little bit of a mess. I can actually talk a little bit while we wait for a few more people. So I have Christina from, I believe, a law firm, right?
Abelson Perez Law, yes.
Perfect. So I assume y'all are just learning how to kind of prepare the accounting, right?
No, I mean, we've been preparing them for a while. We were just kind of curious about some little strategies, things we've come across with getting accountings approved.
Perfect.
And hoping that there's a little bit more insight.
Oh, gotcha. Just realize that the class, I kind of will gear it more towards propers and ask them, you know, what they're going through, what they're experiencing. And so a lot that I may start with, especially when it starts with the inventory and appraisal, you guys probably know, and it's kind of going to be boring for a few minutes, but if you just hang, so how the program will start is I will start off with the inventory and appraisal. Rex, I will give it over to Rex, who will do the accounting portion, and then I'm going to come back on the petition for approval and how to write that and kind of things to write in there. So depending on, like, if you already know the inventory and appraisal and this all would be boring, then you can kind of gear away for a few minutes and then come back to the accounting. But just understand that really my focus is going to be on the propers, you know, and letting them talk or letting them tell me. Okay, perfect.
I totally expected
but that. I want everybody to join in, so I'll ask a few questions just to make sure as we go along, y'all are awake. You see,
Oh, there's a test.
there's a test. No. And Sonia, you're also from a law firm. Welcome. And
Yes, thank you.
you're gonna be just learning or picking up a few more skills on the accounting, I assume.
Just trying to fine tune some of the skills we have and make sure we're not missing any important
Right on.
points.
Right on. Okay, so then we have Tamara Allen, who I know is a client, and who is she is helping, I believe, her husband with a probate case that we have. So she's gonna be more on the pro per side that I'll kind of work with and ask questions and kind of go along. This is more or less for them. So again, some of the stuff might be a little bit boring for y'all at the law firms, but but we'll have fun anyway. I'm gonna try and go through this rather quickly. Sometimes it goes till about 12:30. We actually changed the brochure because we had it earlier that it stopped at 12, and we just couldn't get all the material covered by 12. So it did go to 12:30, but we may kind of push it a little bit faster to see if we can get it done by like 12. No guarantees.
I didn't get your name. I'm sorry.
Sorry, it's Tamara.
Tamara.
Tammara Brown. And just to introduce myself, and Rex will introduce us both also. I am an LDA in 2 counties, Napa and Contra Costa. I am a certified mediator. I have I'm certified CTEC. I'm a notary. So I do a whole bunch of things, but we've been teaching this class on court accounting 5 years?
5 years, at least 5 or
At least 5 or 6 years. We give the class about every 2 months. It used to be more in person, and then COVID brought us to doing it on Zoom, but we've actually decided to kind of continue on Zoom because then more people in larger areas could come and be able to go through the class also. So we've really just enjoyed it. You can watch, it's a free class, so you can watch it as many times as you want. I will go through a few scenarios. So I do quite a bit of the court accounting. I review a lot of court accountings that can't get approved, or whether they're pro pers or law firms. I will take on the project of reviewing court accountings and making sure there's no mistake, or a lot of times other LDAs come to me and go, I just can't figure out what the heck I'm, why I can't get this to balance, or this, that, or the other. So as we go through, I will give examples and kind of scenarios of what I've seen in the past and what technically happens on a lot of them. But of course I would never give client specific, and we'll use some examples of my own, like whether I say my father because he's an elderly person, and just the things I've experienced going through with him. So that's really how the program will go. You can ask questions. Of course, as you know, I cannot give legal advice. I'm not an attorney, although Rex is. You may ask him, but we are going to kind of limit most of the question. I mean, I do want to hear a few questions so that other people can hear your questions also, but I can't get into lengthy discussions or questions because we just would run out of time. I mean, I could talk all day, but y'all don't want to be here for that. So I'm gonna go ahead. It doesn't look like we have any more people logged in, so we can probably start now that it's 9:11. So I will let Rex start. This is the accounting workshop brochure that excuse me, we have updated into 2023. This is found at the courthouse, in the probate department, in the law library, on the law library's website, on the court website. So it can be found multiple places. This is me right down here. And I think in the accounting material, you will be able to find, and I don't know the page, maybe I can find it in his thumbnails, where if you wanted, no, I don't see he included it. My contact information, I can provide that later. Rex will provide his contact information. I don't see that you've included anymore here anymore. Any fiduciaries or LDA, that spreadsheet, brochure that lists,
You're talking about our upcoming classes?
no, contact information.
I don't know.
I'll find it for you. Go ahead, you can start the introduction and I'll,
This is where I start from.
do you need to read from that?
Yes,
Oh.
that's my outline.
Okay. I'll have it right here.
Hello, I'm Rex Crandell. I'm gonna try to get this thing situated. I'm gonna make some adjustments first. There we go. There's an adjustment. There's an adjustment. Okay. All right. So it's takes a little while getting warmed up, get everything on the front burner, getting these classes going in the morning. As you know, we have class materials available on our Google Drive. Is there anybody here who has not gotten our class materials? Okay. Let me explain what we have. First is our the handout that we're going to be going over today, and online is called #1 Handout Court Accounting, and that includes a lot of what we'll be going through, the detail. Another thing that we're going to get into a little bit more detail, this is just overview, is an example of an Excel court accounting that is not on judicial council forms. Judicial council forms are the approved by the courts. And we're going to be covering those in detail because they're the best source to explain the details of the various sections. But I include this Excel court accounting because in my view, it's a work of art, and we can talk about it a little bit more later, but it gives you a contrast. One way we're going to be talking about is filling out the government forms. The other way, and we're not going to cover it in the same detail, is using Excel to come up with the court accounting. But the thing you need to end up doing, this summary sheet is not acceptable to the court. So you have to use a judicial council form GE 400 SUM, SUM, in order to get your accounting filed with the court. Another item that we have in the materials is what I call Rex's non-follow along handout. And this is 24 pages of helpful information that we make available so that as reference material. One is the government forms. We have information on preparing accounting from these sources with court reference material on common errors for accounting, sample pleading paper. We also make available this checklist that you use if you're got a certain kind of transaction and you want to know how to report it, whether it goes under principal or interest. And we've given a code section. I realize we're jumping advanced right here, but it's a good cross-reference when you're looking for something. We've also included, we have this spreadsheet that we make available for $50. It's just a template, nothing fancy, where if people wanted to use this model for doing court accounting on Excel or spreadsheet program. And then another thing that we have included is these are intake checklist forms that we've gotten from the Contra Costa County Superior Court Probate Division. And the people who evaluate all documents coming in before a judge can look at it in our area is called a probate examiner. And the probate examiners will they go through a checklist to see whether your documents are properly filled out or not. And so these are very helpful before you turn in your accounting to the court to see, they're going to be looking at, do you have proof of mailing code section? And it's very helpful inside view because these change from time to time, and we were given these to use. They will change over time, but it's kind of like a last minute checklist. Did we do this? Did we do that? Did we include this? And so those are helpful forms. So the non-follow along handout is just for reference. So our class is given every 2 months. You can sign up in advance. There's no charge for it. We also make our class available on our YouTube channel. We have probably 40 to 50 videos on there of various estate planning, state administration, estate, all kinds of issues related to wills, trusts, estates, and tax. Our YouTube channel is called Estate Planning California, Rex Crandell. And this class will be posted before next week. So you can review this class, review other ones, and you can make a selection on the types of class material you want to see from our library of training materials. The Judicial Council is like the board of directors underneath the Supreme Court of California. And so since the Supreme Court only decides decisions, they have this next layer like board of directors, Judicial Council, and all their meetings are online. You can see them. And below them is the administrative offices of the court. And that's the kind of the office functioning of the Supreme Court and our judicial branch. All of the forms that are required within courts are approved by the Judicial Council. And we are using a workbook called the Handbook for Conservators. And we've pulled pages out for this class. This is a link of where this handbook can be received. The last version was 2016. They've not updated it. And the Handbook for Conservators is probably, I don't know, 80 to 120 pages long. And it is designed for self-represented conservators to give them background on their responsibilities to the conservatee and the court And we have utilized the sections relating to court accounting that is required. Court accounting is required for every probate, every guardianship where there's money for a minor, all the conservatorships, and it's also required for all trusts that do or report court accounting. And you say, well, we got a trust, we're not going to probate, we don't have to follow this stuff. I don't think so. Probate Code Section 1060 says all court accounting shall be done in this manner. And that is what we're teaching. It has nothing to do with the university classes in accounting. I have a degree in accounting. I'm a CPA and a lawyer. And when I was going through accounting school, this subject was not even discussed once. It is a whole area on its own that evolved through California Probate Code. And although other states have similar systems, California, as you might imagine, is the most detailed and tedious. And that's what we are involved in. So it is helpful. You can get the conservator handbook for conservators at no charge. It's online from the courts. It might be useful for you. Other things related to the court accounting. If you are a service provider, a bookkeeper, tax person, legal document assistant, attorney, law office employee, or anybody else, you can do court accounting without a license in California. There is no license. You can offer that service to the public without without having any kind of license. Okay. And in addition, we're going to be teaching the class on how to do the mechanics of the court accounting, but also we're going to cover the other aspect. In order to get it in front of the court, you have to have a petition, also sometimes called a report. And you have to have this report. It discloses a lot of things, plus your court accounting report, and we will cover that. So the whole goal of this accounting is for guardianships, conservators, and probate is to get your accounting approved by the court. If you're a trustee, you don't need it approved by anybody unless a beneficiary demands it, and then it's optional whether you bring it forward for court approval. But I want to have Tamara Brown start now and explain the beginning of how you start a court accounting process.
Of course, I just put a big old bite of bagel in my mouth. I'm gonna give you your copy over here. Away from mine. Hiya, I know, I can spill my own copy, he says. Okay, so I'm gonna start off with the inventory and appraisal. And sorry, let me swallow before I choke. And I just wanted to tell you that the form example I'm going to use is as if it was filled out by a law firm, but those who would be doing it pro per, I will, even though the example shows like the law firm information, I'm going to explain how to fill it out as if you were a pro per. Okay, so the form that we all refer to, or the form that the court would say you need to complete, or the form number that is referenced will either be DE, Decedent's Estate 160, or GC, which is Guardianships and Conservatorships 040. So anytime somebody stated, oh, you need a D160 or a GC040, this is exactly what they're talking about and where that would be located. And again, on the ones for the law firm, we do have somebody here who is pro per, so I'm going to be explaining probably a lot more than you care or you already know. So sorry about that. Anyway, so the form will be completely blank. My example shows what it would look like filled in, but if you can download this form from the internet, please, if you do download it from the internet, it's probably best you use like a court website. There's a lot of other websites out there that will give you the form and it'll pop up first. The court one kind of pops up second or third, I think. Just make sure it's a like court.ca.gov type of form, then you know there's like no viruses or something in it, and or some of the other places actually charge for the form, and you don't need to pay for it. It's not necessary. Okay, so when you are completing this up top, it would actually say your name, whoever the administrator, guardian, or conservator is. If they were completing this as a pro per, they would put their name up here as well as their mailing address, their phone number. Fax number, it says optional, so if you don't have a fax machine, don't worry about leaving that blank. Although email says optional, I would suggest you put an email address in there. The purpose being, if you submit this form and for some reason the courts feel like the form wasn't submitted properly, or they had a question about it or anything like that, they are going to contact you via email. And this is they're going to try and find an email address on file. So even though it says optional, I'd really like, or I want to teach that please find or put an email address in there so the courts can contact you if they have questions. Okay, so under attorney 4, you would actually put your name, and it would be whoever you are. Again, this is example on a conservatorship, but you could be an administrator, you could be an executor, you could be a guardian. So you would put your own name here, and we like to put comma and then the words pro, P-R-O, and then separate word P-E-R, pro per, tells the courts that, or they also use per se, either one of those words. It just tells the courts that you are not represented and you've completed the form on your own. Okay, so under Superior Court of California, my example shows orange. Most of people here would be Contra Costa. So you would put Contra Costa here. The street address 725 Court Street, Department 14, room 212, how all that fits. And then their mailing address, P.O. Box 911. And then Martinez, California, and you can either put the branch name or leave it blank. So let's say you didn't even know what branch. It will tell you like Martinez has 4 court, I think, houses, depending if you're going in family law or civil criminal or probate. They have a different courthouse. So if you leave that blank, sometimes like when I'm filling these out for like down in LA, I don't know the branch or courthouse name, so I will just put probate department. You can do that also. Okay, coming down to a state of, this is the person that you've gone to court for. Now, it could be it's the name, it could be either the decedent, it can be a conservatee, it could be a minor if you're a guardian. It would be a decedent if you're an executor or administrator. It could be any of those, and you would just mark the box, whatever pertains to your case. Our example is going to be, this is a conservatorship. So Jeannie Lowry is the conservatee. And then going down to the rest of the form. So this is an inventory and appraisal. What the purpose of the inventory and appraisal is to provide the court with what are the assets owned at a specific time. And I'll get into, well, what is that specific time? As you look along this side, sorry, I'm going to jump around. So this is the case number. You will have a case number. If it's like Contra Costa, it's MSP. If it's Alameda, it's going to be RP. If it's Sonoma County, it's SPR. So depending on the county, if it's down in LA, Jesus, they have a whole slew of case numbers here, but you just put the case number. Now, the next box is very important. It says it's either the date of death of a decedent. So if you've marked this box decedent right here, then you will put the day of death right here. Now, if it's a conservatee, you will put the day of appointment. So it's not actually the day, and let me be really clear about the date you actually use, because it can really screw up your accounting. Now, if it's a conservatorship, and let's say you got a temporary conservatorship first, and then I think that typically went like 45 days until the permanent conservatorship could be heard by the court, and the permanent you get your permanent conservatorship. This date is going to be the day of the court hearing that the order was signed. So let's say in this case we were the court hearing was on March 8th, 2012. And the court ordered the conservatorship, whether it's temporary or permanent, if you needed a temporary first, ordered the conservatorship. And say, for instance, the court said, oh, you have to have a bond, or you have to go out and get a bond before we'll issue letters. Sometimes going out and getting a bond can take a couple of days, or maybe a little bit longer, because you're like, oh God, how do I go get a bond? And then you've got to figure all that out, or maybe there was holidays in between. This date right here that you would use has to be the date the court ordered you, the conservator or the guardian. It cannot be any other date. So a lot of times people get confused with this and will put the date here of the day that letters were issued, and that is incorrect. Unless letters were issued the same day that the court ordered you the conservatorship. So the conservatorship, I want to say the order is the GC 140. That is the order, and then the GC 150 is the actual letters. So sometime you would go off the date of the GC 140 and the date the judge signed the order. That's the date that you are actually responsible for every single asset of the person that's listed in this box right here. So is the date clear on what to use? And the reason why it's super important, and maybe I'll go on a little bit because I just asked a question. Is everybody clear on the date you must use here? Everybody got it? Cool. The reason why I'm stating this is sometimes you are responsible for your court accounting on this exact date that's coming through right here. So say for instance, you say, okay, the court ordered that I marshal the assets as of March 8th, but I really didn't get my letters to be able to go to the bank and take control of the assets till March 18th, let's just say. And from March 8th to March 18th, that's a 10-day period. For some people, there could be a lot of transactions that happen in between that date. And you're going to say, well, I couldn't even get to the bank and get control of the bank or what happened from March 8th to March 18th. Doesn't matter. You are responsible from this date going forward until the court releases you for every penny that goes in and out. Also, the other important thing is, and we'll get into more details once we start figuring out the beginning balance, is it's very important that you, on the day that you're showing right here, you figure out from the bank what was the balance as of that date. Because when you start doing your accounting, which will be coming in the rest of the training, the court is going to look for a balance on this specific date. If you start your accounting, say for instance, on the 18th, when you got your letters, the court's going to go, no, they're going to reject it instantly because you haven't included that 10-day period. So again, it's really important you have the proper date here. And a lot of times when I'm reviewing accountings and why did they get rejected by the court, because the court won't necessarily tell you why they're rejecting it. These are things I'll look for. For instance, if somebody comes to me and says, Tamara, hey, I need you to glance at these accountings for me, or just I can't figure out what's wrong. First thing I'll do is, okay, send me a copy of the order. Okay, send me a copy of the letters. Okay, send me a copy of at least the first bank statement. And those are the three places I start, because I'll tell you 9 times out of 10, right there, I can solve all of your accounting problems, because typically that's the #1 reason that accountings get off, or they're not proper, or they're rejected by the court. So again, if I was reviewing somebody else's accounting on why, those are the first 3 things I'm going to look for. And then if I don't find anything wrong with the information from then I'll start going, okay, I may need to see the rest of your bank statements. I need to see your accounting, and I need to see, or I can figure out typically why your balances are off. So that's why this date's really important. Okay, so we're going to go on with the inventory and appraisal, and which box would I mark? So if you were doing a partial, so say for instance, you received your conservatorship from the court, and the inventory and appraisal, you have a certain time frame. In fact, I'm seeing more and more, I think with Sonoma County, that they want a CMC or a status conference within, I think it's 60 or 90 days. And what is the status conference? So on a conservatorship, a client got appointed the conservator, and within 90 days, the court said, we're having a CMC, you need to attend. And they were like, okay. And what it was the court wanted to see the inventory and appraisal. They wanted to see another form, which is the GC 335, I believe, which states what's the status of the conservatee, like especially if you're moving them from one home, so from their primary residence to maybe they need to go into a skilled nursing facility or something. The court wanted to know status, and they wanted to provide the inventory and appraisal. So it doesn't necessarily mean when you complete an inventory and appraisal that it automatically goes with an accounting. So you may complete this and then a long time later file an accounting. Well, say that's the case, because I get to myself a lot of conservatorship accountings where conservatorship has gone almost a year and the person didn't realize that they needed to do any of this, or maybe they filed the inventory and appraisals first and now they need to do an accounting. So if they were to come to me, first thing I'm going to say is, let me see your inventory and appraisal. I make sure it's accurate before I even start or even look at the accounting. So it's important. So a partial would mean, like, say for instance, the court wanted an inventory and appraisal done. You haven't figured out, maybe there's parcels or there's real property in another state. You haven't really been able to gain control of that or whatever. Then you would mark this as a partial. I've got a weird, his fan or air conditioner is blowing right down on me and making my nose tingle. Anyway, okay, and then there's corrected. Some people like to use this corrected box, and I don't. Some people like to say, for instance, you turned in an accounting and say it's wrong. So a lot of times propers will turn in an inventory and appraisal. I will go to look at it when it's time to do the accounting, and I'll go, yeah, the wrong balance is at the wrong time or whatever. You need to file a corrected. I mark it a corrected one, but I'll also mark it a final. Some people will only mark it a corrected, depending upon their style, but and when they do a corrected, they only will include on here the stuff that they corrected. I don't like doing that. I usually like to do a corrected and a final so I can see all of the assets on the one inventory and appraisal. But I know there's a few law firms that don't do it that way. So say for instance, there was 5 assets when we get into the Schedule A, all bank accounts, and you recorded the balance wrong. There are some law firms who will only mark corrected and only correct that one balance. But to me, it just seems a little bit hard to follow that way. But you do, however, it works for you. The final means there's nothing more. I've inventoried everything. I have everything needed. There's nothing more to find. I believe this is a final, so I will mark it a final. I use this the most. Reappraisal for sale. The reason why you would mark reappraisal for sale is this inventory and appraisal has values as of this date right here, in this date only. So say for instance, you have, and I'll use a decedent's estate, say we have a probate or even a conservatee. So you were assigned or given letters on the 2012, and in 2022, the conservatee deteriorated and you need to sell their home because they are no longer going to be living there. So there's no reason to keep the home and keep making payments. I would have to do a reappraisal for sale so that I can show the court that now we're in 2022, there's going to be a totally different value of real property. And that's for the sale. Or say I had a vehicle or some, I really wouldn't do a reappraisal for a vehicle. I would just explain it on my accounting. So really I would only use this for a real property. So same thing with a decedent's estate. Sometimes you have a decedent, but the family doesn't know what to do. So they take years and years before they actually file a probate, because then they realize I can't sell this house without a probate, right? And the court ordering an administrator or an executor. And so if that's the case and you want to sell the property, you would do this reappraisal for sale, because this will be, again, date of death values on the inventory and appraisal, and you want to find out how much the house is worth now in 2022, to make sure that when you do put it up for sale, you're not taking a huge loss. Otherwise, the court is not going to be happy with you in the end. There is a supplemental one. I don't use this box either. Again, a supplemental will be if you we're doing more than one, say, partial, you did a partial first, and then now you do another supplemental and you're still not done, so you don't want to mark it final. But again, I don't use that. I would probably do partial number 2 or something like that instead. And then in the end, when I'm ready to do a final, I think I would restate it and just state I'm restating, so that I have an inventory and appraisal that's complete, that I can use to match or start my account. So moving on, is there any questions? I'm kind of almost halfway down the form.
Yeah,
Go
I do.
ahead, hon.
So the reappraisal for sale, I've actually never used that, so I'm very curious about this. I have had that situation where somebody died 20 years ago and they just realized that they don't have to, that they need to have the probate to sell the house.
Yeah.
So are you saying because right, each time we do it, we're paying for the probate referee.
That's correct.
I've just put it in the accounting as a loss, and I haven't had a problem so far. But I'm just wondering if the reappraisal for sale, and maybe this is a question for Rex, would the executor and the attorney compensation be based upon that reappraisal for sale then?
No, the attorney compensation and the statutory fee, you'll see, well, I don't know if I show it in the
Add the gain on sale. That's what I usually do, is if we actually sell it, we can do a gain on sale.
That's correct. Typically, because as you do your petition for final distribution, you have to include in there a line item that says the inventory and appraisal value. But more or less, let me get back to the reappraisal for sale. Let me use the example where I guarantee you must do an inventory and appraisal and mark the box or reappraisal for sale. And that would be if a client of yours is only given limited authority. With limited authority, where you have the court who must approve the sale of the property, the court doesn't know what value they're even looking for, what value the house is, because that's not their job to determine. They have no clue. So if you were going to have a court confirmed sale, you absolutely must do a reappraisal for sale as of the date of the date the sale's taken place. Do not wait until you actually have a signed offer. You have to do it much faster because well, it really doesn't matter, because you still have to petition the court to approve the sale. But the court will not be able to determine value if they look and say, okay, the real property was appraised as of 12/12 and today's 2022. We got 10 years. Like, the property has either increased or decreased. And if the real estate appraisal is doing it for an appraisal for sale, they know whether to come in. Sometimes I'll have the probate referee actually look at the inside of the house if there's a lot of damage, because if he's just going by comps, which is usually how they do it, if he's going by comps, he may value a property at 1 million, but I know we can't sell this property for 1 million because, say, the floors are tore up on the inside, or maybe the walls, have whatever issue, and I don't want to pay for the repair, like paying for the repairs of all that won't give me the gain for the estate, so it's really better just to sell as is.
Mhm.
Again, the court has no idea if your offer coming in at 500,000 is a proper offer, because say for instance in 2022 it was valued at 350, but today, like I said, a real probate referee values it at 1 million, then the court is not going to accept the offer of 500,000 unless he sees a reason why. So that's really a lot of times when you're going to use the reappraisal. And again, that's if you have a limited authority, you don't have permission to sell property and it goes through the courts.
Okay,
But-
so following that example, that's really helpful, by the way. So, for example, we know that the market was really high at the beginning of COVID, which is when I have a decedent. We're getting ready to sell the property now, and it is lowered. So this is a perfect time. I should actually do a reappraisal. Sounds good.
And okay, so here is the other reason that I was going to get to. If you feel for any reason whatsoever that your beneficiaries might be a little bit litigious
Mhm.
or are not going to be happy, if they know or have seen that the property in, they don't really understand what an inventory and appraisal is. And so say in 2012, the real property was appraised at $1 million. I'm just going to use that number because it's easy. Okay, so in their head as a beneficiary, they're going, okay, we're getting $1 million for this property. Okay, right? $1 million. You don't reappraise it in 2022 and they see that really the value now, since the market's dropped or has become a little bit harder because the interest rates have gone up and properties just aren't selling as fast. If they don't see that reappraisal, sometimes I'll do this just as protection to, let's say, the person who is the administrator. I'll do a reappraisal because then the beneficiary within their own eyes see from the probate referee the value of that property really is, let's say, only 800,000. So when I sell it for 800,000, let's say I don't need court permission, I'm just going to go off and sell it right on my own. They have no reason to believe that the administrator acted improperly or acted wrong or lost them some of their inheritance because they only sold the property for 800,000. And so that also is the protection for the administrator, that they don't have to later account or there's nothing going to be brought against them for selling the property at a huge loss, which would be like $200,000 if they were expecting $1 million. So that would be another reason why I would do a reappraisal for sale. To me, getting the probate referee to revalue the property, realize that a probate referee's fees for doing this inventory and appraisal is 10% of the value of everything, or sorry, 1% of the value of everything on Schedule 2. So that cost usually is a whole lot lower than litigating a beneficiary's concerns that you sold the property for $200,000 less. Does that make sense, hon? Okay.
Yes, I'm trying to unmute. Yes,
Right.
that was super, super helpful. So thank
Okay, so that's again another reason why I would go for the reappraisal for sale. Now, if you're talking the loss may be only like 10,000 or something so small that you can explain in an accounting or your petition for a final distribution, then no, don't bother going through the whole inventory and appraisal and all of that. But again, it's what do you want to protect, and is it worth the money to redo it, or is your explanation in your petition for final distribution going to be just good enough? That the market's crashed, or that you know, say you have to say that squatters or homeless people got in and ruined the property, and it just wasn't say for instance the decedent didn't have the cash to do the upgrades, or and I do know that a lot of times the so a lot of times the realtors that are selling the properties may have vendors of their own. So sometimes they will say, or how I see it, they will say, okay, I'll fix up the property, I'll front the money to fix up the property, but I want an extra 1%. So you have to sit there and figure out with like if you're working with an administrator or an executor or somebody, is that 1%, what is that going to cost on the value of the property? Is that 1% going to be worth, are you getting that much more in value on the sale? So weigh those also, because again, you have to make sure that the beneficiaries who are looking and watching all this, and you're technically spending their money, they might be a little hesitant to let you say, go ahead and fix it up, spend that extra 1%, and get the, is there a value from the doing the repairs, or just let it go as an as-is property. Okay, so I'm going to move on. Any more questions? Sorry, I didn't mean. Okay, gotcha. Okay, so I'm going to move on to how do you start this? So we're going to move down to appraisals, total appraisals by representative, guardian, or conservator. It's dependent upon, you know, what you marked up here. So attachment one is the only thing you are responsible for yourself. You're responsible for filling out the other attachment, but not giving value. So we're going to go to attachment one, show you examples. This is attachment one. Again, this will be blank. This follows, let's go back. This is the DE 160. Any attachments will be on the DE 161 form. You will put the estate of and who is the conservatee. I'm going to bounce back. You're going to put the same name you've listed right here. And the case number. And you'll get the case number from the front page. You will need to mark this attachment as attachment one. I wait to kind of fill out unless I know there's really small or don't have a lot of examples. You will put one of one or one of two just to tell the court how many pages you have of this. And I'm going to give examples of what you would put on attachment one. Now, attachment one and what you are responsible for as a proper, as a conservator, as an executor, as an administrator, you're only responsible for valuing cash. And I'll say it one more time, cash, and only cash, nothing else. The rest, everything else would go on attachment two. So right now we are only talking about cash and cash items. So I'm going to give you an example of those cash items. Again, I'm going to use my little aging dad, which I take care of. He's 88. And typically older people, and I say this, older people always have cash on them. There could be cash in an envelope in a drawer. There could be, it's typically the underwear drawer or the t-shirt drawer. Sorry, I'm being honest. but there is cash somewhere in the house. And you know, dependent, it could be in a little jewelry box, it is somewhere, trust me. Older people always have cash. So when, let's say I've taken, this is a conservatorship and I am now the conservator, I go to the conservatee's house and I kind of do some looking around. I know they're older person, so I might look in a wallet. I may look in a little coin purse. I may, if I don't find the cash there, I might look in a jewelry box. I might ask them, maybe they can tell me. Sometimes they can't, depending on, usually if they're in a conservatorship, they don't have full mental capacity, so they may not know. But I'm gonna look around a little bit. Again, I am not going through right away underwear drawers. It's just not happening. I may have to wait, so I'll just go through a wallet. But I can tell you in this example, I'm gonna put cash found and at in what place address. So let me just tell you this example. I myself do not like using where I found cash and making this publicly available unless the house is sold or I'm not, the person's no longer going to be there or what have you. Because of the fact that it's public information and anybody can pick up this inventory and appraisal and know that my conservatee holds cash at her house, that could be a little bit dangerous, you know, in today's world. So I myself don't like to put the actual address. I may put cash found in conservatee's wallet or something like that, or at conservatee's residence, and I'll never just put her address. But it's up to you on how much details you want to put. Just remember, anybody and everybody can get a copy of this form and know what it says. So be a little bit protective if you have a conservatee or a guardianship. Not so much if they're a decedent, because guess what? You can't take from them anymore. Anyway, and here's the amount of the cash I found. You will indicate a total. It more than likely might be $250.01. Our examples show $0, or exact to the penny. I don't know if I would sit and, like, say they had a jar of pennies, whether I'm going to sit there and count pennies all day to figure out that. But I may just say a coffee can of pennies or something like that, and maybe give an estimated value or something like that. I've not ran into those situations, but I may do that. Otherwise, you're just going to list cash found. And let me also say, I have given 7 examples here. You may not have all of these examples. You may not have any of these examples. You may only have 1 example. Please only put on here what pertains to your situation. You don't have to put cash found at residence 0. And, you know, go through all of these and list all of these and put 0 because you don't have it. Just don't put them at all. You would only put on here what you have. So in this case, I have balance in the checking account. I only like to give the last 4 or 5 digits of the account number. You don't need anything more. It's nobody else's business but yours. I will state what bank, whether it's Wells Fargo, whether it's Bank of America, where it is. I don't necessarily put the address either, because most of the time Bank of America's, they could be all over the place, and I don't need to find what branch or address of the branch of the one the conservatee uses. So I will just put Wells Fargo, last 4 digits of the account number. I will tell you, if you are a law firm and you put the entire account number on here, the court will probably give you a pretty stern, nasty letter back stating you are not protecting the person's confidentiality or their private information. So don't put the entire account number. Okay, so this balance, let me tell you right now, this is the number one thing that will screw up every single accounting, and the most every single time I do review accountings, 9 times out of 10, it's this number right here. Why? This number was not the number that was on the day of appointment. This number was, sometimes I get them, this number is, so say you have a bank statement. Okay, let's use this example. I was appointed on March 8th. My bank statement that I received in the mail ends on March 31st. The bank statement does not give me what was my balance every single day. So I just use the balance on that March 30th statement. Guess what? Wrong. Gonna be wrong. You literally, if you do not know the balance, or if you become a conservator or a guardian, or even the decedent, you must know the exact balance on the day of appointment, which is this day you've indicated right here. You must know it as of that date, whether you go to the bank and ask, whether it's shown on a statement, whatever it is, you are responsible for every penny on that date. So make sure this number is for that exact date, no date after. Okay, next one is a savings account, same thing, last 4 digits, put the bank name, don't put the address. And again, this balance must be on that exact date. When I walked into the home, sitting on the counter, there was a CD in an envelope. It was open, but it's still sitting there. I would put the number of it, where it's from, what the name it is. So if you look at it, this example, it seems like Jeannie was an older person. That's why the conservatorship, her husband must have passed away. And so the CD was in the name of both parties, but he's deceased. And because it's joint tenants, typically what that means is if one of them pass away, it automatically transfers to the other party. And so this is now Jeannie's, and what is the CD amount? Okay, it also is, there was an uncashed pension check. Typically nowadays, you don't find this example because of the fact that pensions typically do automatically deposits. Now they don't issue checks. So although some pensions do, because my dad still gets his, but it's dated March 1st, 2021. Now, the only thing you do need to realize is that most pension checks, if you do find them, they do usually have an expiration date on them. So you would automatically look at them and see it. Let's say there was a 90-day expiration date. If we are past that 90 days when we found the pension check, it's no longer good and you cannot deposit it. So you would not include it on this report. So again, be very careful and mindful that so let's say the pension check that you found is dated December 30 or December 1st, 2012, and it has a 90-day expiration period. Well, you got your order or your conservatorship on March 8th. You could not put that pension check as part of your balance or your cash that you have because it had a 90-day expiration date. What you're going to have to do then is take that check and you're going to have to contact the pension, ask them to reissue you a new one because you just found it and it still should have been valid. Reissue a new one, and then you would record that on your accounting when you receive it as opposed to the inventory and appraisal. Okay, moving on, we also have an uncashed Social Security. Typically, again, I will state Social Security checks are automatically deposited. Maybe some are still not. So if you find in an envelope unopened or open social security check hasn't been deposited, you want to make sure you tell the court that you have it, you will be depositing it, and the amount of that. In this case, we also have an uncashed dividend check from Safeguard Investment Mutual Fund. A lot of times there's two different ways for the mutual funds. The dividends can be reinvested, which just means that it will be put back into the stock market, and a different stock or whatever will be, it will just kind of be part of a cash account, or they issue the dividend checks to the person. So there could be two different ways, and in this case, a dividend check was issued but hasn't been deposited yet. So basically you're telling the court, look, in my I have this much cash, this is the amount in my the checking account, this is the amount in the savings, I have this money to deposit. So what is the total amount of my cash assets? So down at the bottom, you will type in total cash assets, and you will give a total of all the cash assets that you have. This number at the bottom here will be carried forward to this number right here. Any questions? Got it? Awesome. You guys are amazing. Okay, so now we're going to work on attachment 2. Attachment 2 is from the probate referee. A lot of people who are pro per go, well, how do I know who my probate referee is? So again, I'm going to refer back to the GC 140, which is the order from the court pointing you as the conservator, or as the administrator executor, or as the guardian. At the very bottom, when you completed your petition for probate, you would have indicated whether there were any assets and what the asset totals were. Like if you listed personal property values, if you listed real property values, stuff like that, the court will automatically give you a probate referee. It will be in the bottom left corner of that DE 140 form. It will state the name of the probate referee and typically a phone number or an address. Sometimes it just lists their name. So a lot of times I'm doing internet Google search, okay, this probate referee, so I can find his address to mail him this form. And say you're given a probate referee and all you have is cash and you don't need that probate referee to value anything, then you just don't send him this form. It's not like you have to call him and tell him, hey, I don't have anything. He doesn't even know he was probably assigned to this case. So there's no need to contact him if you have nothing for the attachment 2. But if you do have, most of the time you will have stuff for the attachment 2, and we will move over to that form. Oops. Attachment 2. So again, same exact form, DE 160. You'll put a state of, case number, and you will fill in attachment 2. In this case, we have page 1 of 1. And what are the items or things that will go on attachment 2? So attachment 2, we're going to list real property. Again, you're going to do the best you can. Most people, especially if you're pro per, will not have all of these details that I do. I have a way to view deeds and stuff on line. So I will get the legal description of the property. But if you don't have that easily available to you, you're just going to give as much information you can. So in this case, we've listed real property in the city of Newport Beach, County of Orange. You would know that information, state of California, described as, and as you can see, they've given the legal description. That's not absolutely 100% necessary. So if I was a pro per and I didn't know that information, I would just put real property in the city of, county of, state of California, commonly known as, and then I would put the address of the property. And here's where you get into that, remember I was indicating that the probate referee is gonna value the property as of this date right here and no other time. So if there was reason that maybe it's decreased in value, or I have even put on here before where clients have wanted the probate referee to actually go inside and view the property. Whether it doesn't matter what the purpose is, but they wanted a real complete appraisal. So I would indicate below here, please do an inside home inspection and have them do that. Whether they charge more for it or not, I'm not quite sure, but you wouldn't be concerned with that. But if you did want an inside home review, I do indicate that on my inventory and appraisals. When you get to the appraised value, you leave that blank because you are not the one that will be valuing the property. The probate referee will actually fill in this value when he gets the form, he or she gets the form. Okay, and so in this case, I also had a vacation home. Again, it's real property, so I've listed the details of it. And again, zero value. Household furniture and furnishings, where at the residence, typically I won't put the address, I will just say household furniture and furnishings at residence. I could say at vacation home, I could say at a primary residence if I wanted to. But typically for household furniture and furnishings, unless, okay, let me back up. Typically, you're going to get a very, very low value. I think a lot of it depends kind of on the size of the home. Like there's going to be a lot more furniture in a 5-bedroom, 6-bedroom home as opposed to a 1-bedroom or a studio, right? So the value of the property typically is pretty low. I see it between 500 and maybe 1,500. That's the most. Doesn't matter. Now, what I will tell you, if there is something that you believe that's worth value, let's say antique curio cabinet with china in it or something like that, I would list that as a separate item on here and let them value that specific item. Just remember that the purpose that you're doing this for is for the beneficiaries also, because they may not know what's in that home, and this helps them give a value of what the entire estate owns. A lot of times, if I don't put something in here, or I haven't, or the proper doesn't put it in there, one of the beneficiaries could come back and go, hey, wait a second, I know there's this antique, I don't know, old stereo that's worth $50,000 or whatever it is. Why didn't I get where's the value of that? Again, if that's the case, I will put that separately and let the probate referee, I'm not responsible for giving value. And if a probate referee gives a value and the beneficiary doesn't like it, they can take it up with the court or that probate referee. It's not me, I'm not responsible for it. So again, list that separately. You will also state how many shares are in the mutual fund. It is up to you to find out how many shares are in the mutual fund. I typically am not this, I will go into a little bit more details in listing of the 1,425 shares, if some are Chevron, if some are Amazon, if some are, and list them out so the probate referee can give a value of those. Otherwise, a lot of people just do put it this way and they do value it. I don't know how they get their information or anything like that to tell you whether it's right or wrong. So that's totally up to you when filling this out. This conservatee also has 7 $100 savings bonds. And so you would list that information here, let the probate referee value it. And then lastly, again, a few things I don't see on here would be a car. With the cars, I like to state the year, make, model of the car. I also like to put the mileage of the vehicle. So say for instance, if I have a car that has $200,000 miles, the value of it's going to be much lower than a car that was never driven and has 50,000 miles on it. So that's a reason why I like to state the mileage. And a lot of times I will state the condition of the vehicle, whether, and when I say condition, if the thing is completely banged up and not drivable or barely drivable, you're holding it together, then I'm gonna admit somebody, sorry, that is barely holding together. I do indicate that. So that would be the purpose of that, but I do indicate vehicles. Also another thing that's here, I show a diamond ring. It's funny, there's a case right now where, okay, let me just back up a little bit. Diamond wedding ring. One, what's the purpose and why would I put it on there? Who cares? Or, just why would I put that as an asset? Say, for instance, your beneficiaries or the children of the conservatee, and they know dad. Sorry, I'm getting feedback. They know dad has bought mom a 2-carat diamond ring, right? One, I'd have a huge problem telling a 2-carat from a 1-carat from a 3-carat because diamonds just aren't my thing. For somebody else, it might be really easy, but I would have a hard time with this. But anyway, listing this, so say for instance, you don't put it, or you put it, it's a 2-carat, but one of the beneficiaries know it's actually 5. They are going to immediately come to you and go, hold up, wait a minute. Did you steal mom's ring and you just put your ring in there because you wanted a better diamond or whatever? Really, this information is just for the beneficiary. So I will indicate that value. Let's move on. I roll down, and then I'll put at the bottom of the form the total non-cash assets, and I will leave it blank because it will be filled out by the probate referee. Any questions on attachments 1 or 2? What you should include, what you shouldn't include, or do you feel that some things should be on the other form than the other? Clear on what goes on attachment 1 and 2? Gotcha. Okay, we're going to go back to the form. Again, that's why attachment 2 is left blank here. You also leave the total blank. Also, the probate referee will return this form to you and will fill in both of these line items right here. Moving down the form, so now we have the declaration. Number 3 will state whether it's all. That's if you've marked it final, or if it's a portion, if you've marked it a partial or supplemental, or if you've corrected, or if it's a reappraisal, it would just be a portion. So that's the difference between the 2 boxes. Okay, number 4, this box. Was a probate referee required? Say for instance, we only had cash, there were no non-cash assets. In that case, a probate referee is not required because there's nothing for him to value. So you would mark this box. Or in our example here, we do have stuff on attachment 2. So I would mark this box and I would say by order of the court, and it would be of this day. So when did the court sign the order, which is the DE 140 again? So the court signed this order on March 8th, and it gave me a probate referee. So I would put March 8th here and I would mark this box. Property tax certificate. It used to be that you could not mark either or, and your inventory and appraisal would, this would still be accepted. Now I am seeing that the clerks will reject your inventory and appraisal if this box 5 is not marked. Box 5 has to do with property certificate. So what does it mean? Why would you use it? Things like that. There are only 2 boxes. So one is there is no real property. In this case, you see in attachment 2, there is not only the primary home, there's a vacation home. So obviously you couldn't mark box A, right? Because there is real property. But I do have many conservatorships or guardianships where there is no real property. There's only cash or other assets. Then I would mark box A. Box B, what does box B mean? Box B typically means that you have completed, let's say if it's a decedent's estate, so if it's a decedent's estate, you've done the affidavit of death of property owner, or if it's a decedent that owned a trust, you've done affidavit of death of trustee or co-trustee or one of those. So basically this box is just stating you've already notified the county recorder and assessor that the person is no longer in charge of the property. Now, if it's a conservatee, you would state that you just tell the county recorder and assessor that this person is no longer able to handle the estate and you are taking over at this point. So one of these 2 boxes will need to be marked. Now, we move down, you're declaring under penalty and perjury that the information is true and correct up here. It needs to be dated. It's funny, a lot of people, and it's so funny, a lot of people don't see this date, so they'll turn them in and they'll only sign their name over here. And I'm like, hang on, you didn't date it. So I'm always reminding clients, you need a date. They won't take this if it's not dated, or they will take it and you're going to get back in your tentative rulings or notes from the court that your inventory and appraisal wasn't dated. So I always tell, hey, look over here and make sure there's a date here. David Lowry is the person completing the form. He is the conservator. So again, that would be you. You would type or print or type your name here, and then you're going to sign it over here. Please note this form, you never sign the inventory and appraisal till after it's come back from the probate referee, because again, you're declaring under penalty and perjury. All of this information is correct. How do you know if it's correct if you haven't even seen what the probate referee has valued and you're signing it already? So make sure this is not signed until it comes back. Now we get down to the bottom part, which is the statement about the bond. There are 3 boxes and 3 different ways to use this, and I will go through. If the court has, when they issued the order, again, DE 140, if the court has waived bond because, say, the will's waived bond, or the conservatorship, they waived bond, or any other reason that, or let's say in a decedent's estate, all the beneficiaries waive bond, then if the order was granted and you did not, there was no bond issue, you mark this box. Number 7 is if the court orders a bond, typically well, that's one of my questions, so I'm gonna leave that. I'll come back. So if the court wanted a bond, you would make sure you would mark this box. And I'm going to come back to this question in just a minute. And then number 8 would be receipts for. So say, for instance, we had a minor, realize a minor cannot say they inherited, they're under 18, they cannot inherit, so it needs to go into a blocked account. Or say, for instance, you have a, well, that's another reason. Okay, so say, for instance, initially you received you became an administrator and then you sold property, and instead of, you were already told you had to have minimum bond, and now you sold the property, so you have $1 million of cash. Instead of increasing your bond for that extra $1 million, you may want to throw the $1 million in a blocked account, and therefore you don't have to increase the bond, because bonds can be expensive and you're not going to use the $1 million until you distribute anyway. Then you can do that also. So let's go back up to bond. So again, this is going to be one of your test questions. See if y'all are awake out there. So initially, the court ordered a $20,000 bond, which is the minimum bond amount that the court will issue. So in this case, the court has issued a $20,000 bond, but if you look up in your attachment 1, you have cash of $57,844.59. Again, your bond is $20,000. So which of these 2 boxes would you be marking? Anyone's question? So we have Tamara on here. Good job, Tamara. You would mark 2, insufficient. Because your bond does not cover your cash, and that's the whole purpose of the whole bond. The bond is to make sure that none of this cash walks away. And believe it or not, it does every day. I don't know how, but every day I'm looking at and going, how did that happen? Cash walks away, flies in the air. I don't know. It never flies my direction, but flies somewhere. And so if that's the case and any of the cash does come up missing or has flown away or was improperly used for an expense or whatever the case may be, the court can go after the bond and have the money replaced. So in this case, you would have marked it insufficient, and likely when the court would see that, they would come back and say, okay, you now have to increase your bond amount to cover this cash. And they'd probably say, they probably want you to get a bond of 60,000 so that you could cover the cash. Okay, we're getting down here. Date, again, a lot of people miss this. Now, in this case, we had an attorney, so we were completing that. So you see Jared's name, but if there's no attorney, you would print your own name. So David Lowry would be in most places, and it would be signed. Okay, now we're getting page, sorry, hun. Does anybody have any questions about the second half? Great. Okay, page 2 of the inventory and appraisal. Again, you're going to use the name that you used on the front cover page, whether it's a decedent, conservatee, or minor, and you're going to put the case number. You are going to leave this blank. This information will be filled out by the probate referee, and it tells the court exactly what they charged and if they had any expenses. And they will give a total here. They will date it. They will print their name or type their name, and they will sign it. Again, probate referee only. You never want to complete this page. In fact, I got one from a client yesterday where the client who was prober, we didn't use a probate referee. And I guess my instructions weren't clear enough because she went and signed this, and I had to white out her information so I could submit it. Because I didn't have time to get her a new one to sign it and get original signature back for filing. So I just whited it out. But anyway, again, you don't fill out this information, the probate referee does. And then the probate referee will return the entire document back to you with the attachments included. This will be completed. Again, they will take that number on attachment 2, they will fill it in here, and they will provide a total. And then you will come back, you will sign it, and you are ready to file it with the court. And it becomes an official inventory and appraisal. Are there any questions? Y'all are just too good and too fun. Okay, I'm actually done with my portion. Oh, what I was saying, which I'll just put it up on the screen real fast if you wanted to, is because I didn't see it in the materials. There is, and I'm going to put it up, an entire fiduciary accounting that the courts give out that has names. Let's see, I'm a little bit sideways, has names of some fiduciaries. I myself am right, oops, wrong side, right here, with my contact information here. Rex is also right here as an attorney, and there are several other people. So if you're interested in the form or my contact information, let me know, and that will be for you. So I'm done now, and we'll switch over to the accounting portion, and then I'll come back and teach you how to do the petition for final distribution, and then we'll be done. All good? Y'all are, wait a minute, Karina, you guys are just having too much fun over there. All I see is laughs and smiles on the your screen. You guys are having way too much fun.
Being pretty excited that now she's going to handle the inventory and appraisals for me.
Right? And she knows how, right? Right on, right on. Okay, guys, I'll be coming back. Okay, all yours.
I just wanted to find out if we're having fun yet. Oh, boy, are we having fun?
We are.
Accounting is fun. We need to say that over and over again, sometimes.
Especially when it doesn't line up.
Yeah. And by the way, I have the solution to the jar of coins. You take the jar of coins to the grocery store and you shove it in one of those machines that counts for you. Then they give you two $20 bills and you put that on your inventory and appraisal. So what we're going to do now, I'm going to say some comments about the inventory and appraisal because it's, anyway, put it in perspective. Now, obviously, we've been spending time in inventory and appraisals at the beginning of your appointment. Now, accounting's going on every year, let's say, on a conservatorship. It's going on. Now, what do you have? I've been calling it an inventory and appraisal because you need a report of your assets at the beginning of the account period and at the end of the account period. And I've been calling it an inventory and appraisal, and Tamara's been giving me raspberries. It's really a statement of your assets at the beginning of the period at carry value, and a statement of your assets and liabilities at the end of the account period. And you'd be surprised how many people turn the court accounting in and they don't have the beginning and ending each time, and the court just kicks it out. So, but it's not on these forms. What I'm talking about there would be just a list of the assets and the carry value. I'll clarify it as we go along. Now, I got to find my place because I have a different start point than Tamara. Okay. So, we have this format on this number 1 handout court accounting class folder. And the way that the numbers, when I start talking about page numbers, everybody looks in the wrong place first. They look in the upper right, and those are not the page numbers. the upper right of each page is the judicial council numbering system. That's not what I'm talking about. So when I say we're on page 23, that's not it. You won't find it. What I've done is I've taken our entire stack of documents, and on each page on the lower left, I have put Bates numbering. So you'll see number 000021 for page 21. And that's really where I'm at. The Bates numbering system won't let me get rid of the 4 zeros. But when I go back and forth, these are my page numbers that we're going to be using. And if you printed out the materials for the class and you have in a binder or something, some way or another, or a tab or a bookmark or something, this page that I'm going to talk about first is pivotal in that we're going to go back and forth from every other document coming back to it, another document and coming back to it. So we will refer back to this on page 21 many times. I don't know if your page numbers on my PDF program, it says page 23, but I can't say that because the form itself says page 21. Okay, so now that we're on first base, we're going to talk about the GC 400 sum, meaning summary. GC, guardianship or conservatorship in court speak. Sum meaning summary. And goofy numbering, courts always come up with the goofiest numbering and sequencing systems. All of these forms we're going to be dealing with are GC 400. They couldn't come up with anything else. So we're on the sum, but there's all these other schedules that you'll see, and all of them start out GC 400 sum. And when you're doing a court accounting, this summary sheet is on top of your entire report. Every time. Let me show you something else. Okay, so when you're doing a court accounting, as we said, we need for guardianship, conservatorships, and probate, mandatory. Optional for trusts, but you have to use this exact form. Now, earlier, I'll bring it back up on the screen. I had another page that came out that was an Excel spreadsheet that is a summary of account. And what happens is people use this summary of an account and they say, it tells the same thing as the GC 400 sum. It's got the same data. You turn it in and the probate examiners are going to send it back to you. They're not going to accept it, only in trusts. So what you have to do is this summary sheet that you end up tracking while you're doing all of your accounting. When you get done with everything and everything's perfect and you balance, you have to transfer the data onto the government issue form, the actual GC 400 sum. Otherwise, the court's not going to take it. And when you turn in your accounting, we'll get into it more detail, but you end up having to turn in with your accounting, the entire accounting period, all of the bank statements that you have during that period, all the original bank statements. And people say, oh, I'll just print it out from the online. No, you won't. Court won't take it. If you print them out all on the online statements, you got to go to the bank and have them stamp it for authentication. The court's really picky about getting all original bank statements. You do not, as in most counties except San Francisco, you do not have to turn in your receipts. If they want them, they can ask for them. But original bank statements, absolutely. And then there's a cover sheet that you put on top of the bank statements as an attachment saying all these bank statements and this are attached. Okay. Now, back to GC 400 sum. So we set up the original top of the form, whether it's guardianship, conservatorship. It might be probate, write it in. It might be a trust, just write it in. And we're going to start out doing the first account. As of the date, your letters, I want to clarify the word letters because it wasn't defined earlier. Letters means when you were appointed as the executor on a probate. It might also mean for guardianship and conservatorships, but the term letters by itself is ambiguous, but that's the start date for your counting. Okay, so beginning assets at the beginning of the account period. First of all, this form is divided in above and below. We got pluses and minuses. Charges in the top, credits below. Now, I absolutely disagree with the way courts do wording things. Charges, that's what the term is, charged responsibility. So you have to look at being a trustee or executor as a burden because you are liable for all the funds under your control. And if they disappear, it's called personal liability. And so the term charge means what is your responsibility for assets? So we have the beginning numbers, and this came from your inventory and appraisal. The cash, no appraisal there, and your non-cash. So it's a copy job from the forms we've already talked about. Then we're going to be adding things that happen during the account period, additional property received, receipts, gains on sale, other charges. Fortunately for fiduciaries, if there is a trade or business, all you have to do is list the net income from the accountant doing the reporting. And fortunately, because if you've got an ongoing business, you don't want to have to do every bookkeeping transaction for that business. Then we get to the term credits. And the credits are when you have justifiable disbursements from the funds. Now, I've got a degree in accounting. Charges and credits means nothing in terms of accounting. I mean, debits and credits, yes. Does it match? No. So if you know debits and credits, forget it. It's only going to confuse you. So when we get into the credits, you're relieving your burden, your carry value, and we're showing what we're showing is distributions. Then we get down to the end of the account period, and we have what's left in cash, and then we have what's left in the non-cash assets. And then on line 14, we're supposed to match with line 7. And if it doesn't, you're not done yet. The courts, even IRS doesn't want pennies anymore, but the courts are more anal. They want everything reconciled to the penny. And they're not letting you use round dollars. Okay, that's just the way it is. So we're going to be going down through these schedules. In each of these line items, you can think of it as a link to a series of other schedules that we're going to be talking about. And all of them flow back to this GC 400 sum. In the lower left, I mentioned it before, but you'll see the judicial counsel printed on this form above the page 21 sign that these are adopted for mandatory use. Not maybe, not if you like it. There's no choice. It's mandatory. And on the bottom, it says, okay, probates, all right, conservatorships, all right, guardianships. But you can also add the term trusts, because when trusts do accounting, this is the format that is used. Another thing I wanted to point out is, yeah, some of this stuff makes sense. Some of it's intuitive. Some of it might be ambiguous. And so you say, well, where do I go for additional information if I don't understand what's a definition of a whatchamajiggy? And in the lower right of the form, there are probate code sections. And that's what I call a breadcrumb trail, where you can look up what this form came from a code section. So you can go back to that code and see, maybe it might define what's a whatchamajiggy in this context. And the probate code is, I'd say, somewhat readable. It's not as goofy as the Internal Revenue Code, because the Internal Revenue Code gets halfway through a sentence and gives you a code section and another reference, and then you do a little bit more of a sentence, and then they cross-reference. You could never get to the end of the sentences in the Internal Revenue Code. But these make sense, somewhat. And then beneath that shows the California Rules of Court. Those are statewide rules that the court requires, and they're codified. And then some counties have their own rules called local rules, which we'll talk about. Okay, so we are going to go through the details of what you need to do, and now we're in the numeric part. So we're going to move to page 21-1A, page 21, 1A. And you remember the inventory and appraisal, this is on their first account, this is really just a duplicate of your cash on hand for inventory and appraisal. But it might be duplicate, but I would include it again. And then you list the total cash assets. And then we go back and make sure it shows on the GC 400 sum. So what we're going to do is take all these summary numbers and walk back into the detail where they came from. This one is a copy job, I said, from the inventory and appraisal. And so is this one. This is GC 400 PH. This one is the non-cash assets. This is what you had appraised. One suggestion when you're doing a court accounting is that once you set up your asset list, so you've got bank account number 1, investment account number 7, property number 14, keep those line item numbers the same throughout the entire life of the guardianship, conservatorship, or probate. Don't change those, because otherwise it's hard for the readers to determine which assets are we talking about. So even if we have, let's say, item number 4 on our inventory and appraisal was a house in Anaheim, and later we sold it, and that was item number 4, well, it's going to drop off our beginning and ending assets on hand, but I'm not going to use that number 4 again. I'll just show my list of assets 1, 2, 3, 5, because the cross-referencing doesn't get lost. Okay, this is a handy schedule on page 22 that is kind of a summary. We're going to get into the details of subschedules, but this is kind of a cap sheet within sections. So what I mean by that is there's all these different receipts, translated income categories, and we'll have schedules for each of these. But this is kind of a summary sheet before we get to the GC 400 sum. for inbound funds and outbound funds. And the court says that you don't need to turn it in with your accounting. I find it's useful to try to work back into the detail of the schedules. Okay, now we're getting into the 31 flavors of accounting schedules that the court has made available to us. First of all, you know, already discussed that 90 days after you get your letters, you got to turn in your inventory and appraisal. But now we're doing something else. We're doing the transactions during the year. So when you're listing transactions, these are dividends from an investment account. You have to list every transaction. You cannot say, oh, I received $1,200 of dividend income from the Charles Schwab account during a month or the quarter. Can't do it. It'll get kicked out. You take the investment accounts and the bank accounts and you enter every transaction. And we're only going to be covering today the most common schedules for receipts and disbursements, but online in the court's websites for judicial counsel forms, there are 48 different types of revenue and disbursements categories. So if you don't find something, you got an unusual transaction, look around, there's probably a form designed for that transaction. So let's say you're the executor or conservator and you have in the assets, a portfolio of securities. And in every transaction, there's a whole bunch of dividends being issued. And the dividends turn around and they're buying more stock. So it's really two transactions at once. The technical term is a dividend reinvestment program. I call it a whole lot of unnecessary work. We abbreviate that transaction as DRIP, dividend reinvestment, and it will drive you crazy on big stock portfolios. You got tons and tons of dividends. You got to report every transaction. And then you got tons and tons of reinvestment. You got to report every transaction. You just quadrupled your work. Tell the broker, stop the drip. Every dividend put in cash and I'll deal with it later. You'll see what I mean when you run across it. And it's strictly okay. You don't have to have dividends reinvested in stocks. It's not required, or it's not illegal, immoral, or fattening. It just makes less work for you. Okay. So receipts from dividends. Then we go on to receipts from interest income. There again, list by bank. Maybe the last four digits of the account number, and then each of the transactions. Now, pension income, you list those, each individual item as they come in. Here's rents for rental income. So if you have 2 or 3 rental properties, we will have those separated by property. Now here is another receipts schedule. Social Security benefits. We had a probate examiner from our local court take this class. We got to this page and she blew the whistle on it immediately. She says, you can't do that. They lumped 3 months worth of Social Security payments in one line item. No can do. Every little transaction has to show. This would not be acceptable. Okay. Receipts other. This receipts other schedule is you can translate that to miscellaneous. Anything else you didn't find, just throw it here as receipt of income. I know this is exciting, but try to stay awake. Okay, gains on sales. This is we're showing a house sale. So we have the house in Palm Springs. Our carry value, you'll recall that the probate referee gave us the carry value. And then we sold it. Well, the contract sales price in this example is $250,000. So what the court wants you to report is sale price less your carry value. And then you're supposed to report here, that's the gain. I can assure you that is not the gain, because they ignored the whole feature of escrow sales costs. But this is what we have to do. So it's carry value compared to sale price, and this arbitrary gain is going to sit here for a while, but we're going to come back to the escrow costs and list those separately as disbursements. Now we're on page 30. Disbursements, conservatees, residence, or long-term care facility. We had one client that was paying $150,000 a year in housing costs. I'd say that's rather high, but he had a lot of medical care along with it. Disbursements, general and administrative, you can translate that to miscellaneous disbursements. Just list them out. So you got reimbursable costs for court filing fees and other types of things. Living expenses for your ward, conservatee. There's no real order or rhyme or reason, just list them out as they occur. Medical expenses, list them as they come in, and it's the if other people are paying, like this would be the copay. In other words, the amount that the guardianship or conservatorship pays, not the total amount of the bill. Now, on page 34, in the lower left, we have disbursements, property sales expense. This is where we're showing the escrow costs. So we've got the cost to sell the Palm Springs property. We have escrow fees, broker's commission, and then we have the total sales expenses. One of the most unusual things on a house sale that just seems mind-boggling to me, out of all the numbers in a house sale escrow, the net amount of cash on the escrow sales sheet never gets reported anywhere. It's irrelevant. The net proceeds, because after you get done reporting all this stuff up above, the net proceeds just happens, it's there. In other words, you don't bring it in any place, because we took carry value, sale price, now we went through all the cost of the escrow anyway. And in this case, we had a sale, a payoff of a second loan. This is a separate type of property sale. So we had a bunch of crud in the house that we sold, and we sent it off to a consignment shop, and it was all sold, and we had to pay a consignment fee. That's what the expense here is. The things that were sold end up showing in just revenue items. Now we have disbursements for rental expenses. Since we do a lot of income tax, I always thought it made sense to show rental property with income, expenses by categories, and net rental income. Well, one time we had a situation where there's about 8 to 10 rentals, and we wanted to show all the details so the judge could see what was going on. Oh, did they hate that? Oh, you can't use landscape format. Oh my God, this is a court. What are you doing landscape? Ooh, and your fonts are too small. Oh my gosh. And no, you can't use columns. Sorry. We'll put it on this stupid format so you can have it the way you want. All the rental expenses sequential. You got it. You wanted it, you got it. You can't see anything, but it's just the way you want it. Okay, now disbursements, tax repair fees, IRS tax due. It's kind of a miscellaneous type of item here. Loss on sales of assets. Okay, so we've got the Jalopy Oldsmobile with peeling paint. And we have a carry value of 3,100. And we just sold it to some sucker for $3,000, and that's their problem. And then so we're going to end up showing a loss of 125, and then the asset will drop out of our asset list for the vehicle. And then 125 will just stay out there as a loss on sale of assets. Okay, cash on hand at the end of the account period. Remember when I started out, I said we had inventory and appraisal, but I can't use that term because I got in trouble for it from Tamara, and it's just beginning assets on hand, and then I go end of assets on hand, and now we're at the end of assets at the end of the account period. So we list the assets in the same asset number list that we did before in the beginning, and now we list the non-cash assets, and those are our totals. Okay, now let me go back to the page 21 someplace. There we go. Okay, so what we did here was we went through the schedules on all the income items. And we're totaling them out in these groupings. And people have asked before, say they were on a schedule and they're not sure whether, how do they know, what do they, if they can't remember what it is? Read the form. It's not that tough. The form is already printed out to tell you what to do with it. Then the disbursements. We went through all the disbursement list, and now we've talked about the assets on hand at the end of the account period. And lo and behold, for small miracles, our line 7 balances with line 14. Don't assume that you're going to be that lucky first time around. It's not going to happen. But you can pray for it. You know, one thing that I tell people to do since from accounting school is when you're adding up numbers, everybody, what they do is oh, I'm going to add it up really quick and write it down. No, what you do is every set of sequence of numbers you add up, you write the number down, and then you go back to your detail and you verify each number that you keyed. Because if you key something wrong, it takes you half a second to find it in this method before you use the number, and it's going to take you 3 hours to find it later if you omit this step. So I won't use a total number without verifying the source details. I've learned that by experience. Okay, so does anyone have any questions about the GC 400 sum?
Yes.
Okay, go ahead, please.
Hi, in the page 40,
Yes,
Oh, what's the difference between the estimated market value and the carry value?
Good question. Okay, so we're on page 40, non-cash assets at the end of the account period. If you recall, when you had the appraiser come out, these probate referees, I call them second gear appraisals. They get in their car and they drive by in second gear and they say, oh yeah, that house is worth 1.1 million. And then they keep going. Okay, we got a real exact number now and we have to use it. So that's going to be your carry value. And you're going to use that all the way forever until the property's sold or distributed. Now, estimated market value is, there's some technical terms that you learn in accounting school, one of which is swag. And when you're doing a lot of numbers, sometimes that term comes up. And the long way to say that is some wild ass guess. Okay. And what we have here now is that's the number we're using. How did you get it? Zillow. I don't know. I think it's still worth 92,000, but on stocks, you can find them because it says 1425 shares. Your broker statement will say it. You have to, you're only using reconciled broker statements and reconciled bank statements. So stocks fluctuate in value. The rest of this stuff, don't sweat it. Get on Zillow, look at it, put it in, diamond, wedding ring, forget it. Just leave it the same. Other things, the $6,000 of household furnishings that are worthless, just leave it at 6,000. Don't bother losing any sleep over it. The purpose of this and the way it's utilized in real life is, let's say you're the trustee or conservator and you've got this big portfolio and you think you're the latest guru for investments. Wonderful. And you're doing all these investments, and at the end of the account period, when they got a handle on it, when you started, it was worth 92,000. And then with your expert stewardship, you get to the end of the account period and it's worth $2. Uh-oh. Something happened. And it gives the readers and beneficiaries a heads up that maybe something's not quite right in that investment strategy. And the purpose of it listed in the accounting reports is you get the judge to approve the accounting report, and the beneficiaries can't complain after that time because they got notice of the accounting. So that's the way it's used most effectively. And it also, for the beneficiary standpoint, it can also cause litigation. Because the bozo who thought they were investment guru and they lost everything, now they might end up finding that they have a breach of fiduciary duty case against them for personal liability. So, but to answer your question, where do you get the numbers? Just remember swag. That's it.
I love that, by the way.
Thank
Thank you.
Yeah, we got another one, by the way. You learn all this wonderful stuff in CPA school. Another one you need to know is MyCore. Now that one's extremely technical, and but you'll find out it does come in handy, especially in small pennies and things. MyCore is another concept for make it come out right. And sometimes MyCore is one of your best friends, especially when you're 2 cents off. Hell, tape it on there and send it in. Okay. So those are kind of what do you call experience from the trenches.
Just on to continue on that particular worksheet that we were talking about. So for the single family residence,
Yes.
so that carry value, the 950 was the probate referee, for example.
The probate referee value.
Yep. But then we look on, we look on Zillow and we realize, wow, there's been an increase. And so we move it up to 1.1
Okay, on the estimated,
on the estimated market value. That's
correct,
what we do there. Okay, and then what number, and I guess I just need to look real quickly, gets carried over to the actual summary of accounts?
okay, good. If you look on the page 40,
Uh-huh,
we've got 1.047 million
yep,
and carry.
yep.
Then we go back to the page 21 and it should be showing there.
Yes, it is.
Okay, so in other words, what you end up getting used to doing is carry value.
Okay.
It's
So really,
always, oh, hold on, it's carry value. It's comparable to income tax. We get into this term called basis,
Mhm.
and that's basis for gain or loss. For this imaginary world of court accounting, we can't use the word basis because it's ambiguous. So everything's going to be carry value.
So you never really used it.
You had
So-
another sub question.
so we never really use that estimated market value.
No,
Okay,
we like to
What-
call that informative disclosure.
got it. Okay.
You were informed. Now, tough luck. You heard about it. We got our court accounting approved. You can't whine, moan, and complain anymore.
Okay, great. Thank you.
Okay, what other questions do we have on the GC 400 sum? Hearing none, I'm going to pass the gavel to Tamara, and she will continue this exciting program on to oblivion. Hold on. All right. I'm doing it on purpose.
Hi guys, back already. Okay, we're gonna start the petition portion. Fun stuff. So now we've turned in the inventory and appraisal. And we've turned in, we have an accounting done, and now we need to ask the court or tell the court what we want to have done. I'm gonna slide through and go straight to the petition, which I don't see page 1 of that petition. One. This is odd. I don't know where he's put it. I'm so sorry, guys. Here it is. Okay. We'll get to it. I think it's here. Yep, it is. Okay. So now you've done your accounting and you need to do a petition for its approval. I do mine kind of a few different ways depending upon what's going on, but this would be a standard example that you can use. Please keep in mind, it must be on pleading paper for those who are not in a law firm. Pleading paper can be found on the net. You can get it. It will turn it into a Word file where this is all already provided for you. And then you just complete the lines, but you cannot submit the petition any other way. So, a stupid fan. Okay, so again, we're going to start with what should be up here. Up here should be your name, your address, your phone number, your email address. And instead of attorney for, you would just put your name, comma, pro per. You would type Superior Court of California, County of Orange, County of Contra Costa, County of Alameda, County of Sonoma, whichever county you're in. Over here, you have in our example for the inventory and appraisal, it's a conservatorship. So you would state conservatorship. And This one says of the person and estate. Well, you really wouldn't be doing an accounting if it wasn't of the estate. You don't need to do an accounting if you're just a conservator of a person. Sorry about that. So then down here, we have the name of our conservatee. This would be the name of the decedent, name of the minor, name of, depending on how your case is. If it's an also known as, sometimes, they go by their maiden name, sometimes they go by initials, sometimes they go by an entirely different name, especially if they're, of a different nationality, and maybe they just don't, sometimes they go by their middle name first. So you have to file a conservatorship or a probate or something like that under their real given name. So I will also indicate if there is an otherwise known as. And down here it says conservatee. And if you were doing a decedent's estate, you would put decedent. If you're doing a minor, it would be a guardianship. Okay, on this side, you would start with a case number. I don't know why this has this, but I always separate or have a line between the case number and the title of the document. Title of the document in this case is the first account. Remember, for conservatorship, accountings do the first year, and then every time after that, every 2 years. So it could be your second account, it could be your third account, depending on how many years you've been doing a conservatorship. For a decedent's estates, typically your first account and your only account. For a minor, again, it could be first, second, third, it could go on and on. So you will list that, and in this case, you're saying this is the report of the conservator. It could be a report of the administrator, it could be a report of the guardian. So use the words that are appropriate to your type of case. You're asking this for this to be a petition for the settlement of your accounting, for the approval, and in this case, there what must have been in the accounting example, a sale of depreciating property. So there's an allowance of fees to the conservator. Remember, in a conservatorship, you can never pay yourself. Administrator also of the estate, you can never pay yourself. And in a guardianship, again, you can never pay yourself until the court approves it. And this is the only way usually the court approves. Sometimes I've seen, when I file the first account, if the conservator wants to be paid like a monthly, let's say, stipend or a monthly fee, we will ask for an automatically monthly fee that can be reconciled in 2 years. Otherwise, the conservator has to go the next one 2 years before they're paid. So if you have a conservatorship and you want to ask to be paid for a decedent's estate probate, you do not get paid until you're issuing your final distribution. So you just have to know you have to wait that long before you will be paid for that. Also, if the attorney is if there's an attorney in the case, and the attorney will not get compensation either until the very last end. Or for a conservatorship, it's when this accounting is approved. If it's for a guardianship, again, it's when the accounting is approved. But if it is for a probate estate, it's when you issue your final distribution papers. So a lot of times, attorneys already know this. A lot of times that you're not being paid until this is approved. So sometimes I can tell you, and you have to be able to do this if you're if you are a paralegal or somebody who's working on your own, like an LDA. I have cases that I've gone and worked on for 2 and 3 years, and I still don't get to be paid until it's ready for final distribution. So you just really have to realize that. Okay, in this case, we have, we know the date of hearing. Most of the time you will fill this out not knowing the date of hearing. So you will put date of hearing, you will leave this blank. And when you go to file it with the court, the filing clerk will give you a hearing date. They will either stamp it in with their stamp or they will handwrite it in for you. They will also put the time, and you will know the department because the departments don't change. Once for Contra Costa, it's either Department 15 or 30. So you know when you first file the case what department you're in, you will remain in that department. So you will know the department. Judicial officer, I myself don't like writing the judicial officer in there. You don't know if you're going to have a commissioner sit in, if you're going to have a pro tem sit in, anything like that. So I myself do not include the judicial officer. I will leave that blank. Most of the times I don't even write this line on here, because you will see later, you will include it within the wording anyway. Well, actually, it's on the order. Okay, so how you're gonna start this out is, I'm gonna just read this as like if I'm completing it. So I am the petitioner. My name's David Lowry. I am hereinafter gonna refer to myself as the conservator. Again, you're doing a decedent's estate. You can say hereinafter I will refer to myself as the administrator. Hereinafter I will refer to myself as the executor. Hereinafter I'm gonna refer to myself as the guardian. It just makes it easier. So when you're talking about the conservator, when you write it like this, the judge knows you're talking about this person, whether you're writing it up for yourself or someone else. Okay, so I'm David Lowry. I'm the conservator for the estate of Jeannie, who is the conservatee. I present for settlement and allowance my first and current account and report of the state as the conservator. I, as the petitioner, respectfully state, and this is what you would include in your petition. Remember that anytime you're completing a court document, whether it's a petition, whether it's a declaration, whether it's whatever it is, keep in mind that this paper, any documents you submit to the court should stand on their own. And a lot of times you'll hear attorneys stating that. Well, what does stand on their own mean? It means I should be able to read the entire case in this petition. It doesn't mean you're not telling me, yes, I was appointed, but go back in your own court records and look it up when I was appointed. Try to tell the judge that he's not going to be very happy with you. So you really, the reason for some of this, even though you say, well, he should know when I was appointed. Yeah, the judges go through a million cases, you know, all the time. They cannot remember every single case right off the top of their head. So it's really nice that you present it in this fashion. So I'm going to start it off with saying I was appointed as conservator of the person and the estate. Again, if you were only a conservator of a person, you wouldn't be doing an accounting because you're not responsible for money. You're only responsible for the person. So you wouldn't be doing this petition. So it would have to be of the estate of the person, also known as Jeannie Gray, the conservatee. Again, see this March 8th time, this came off my inventory and appraisal. And again, this was when the court court ordered me, the conservator, and letters of conservatorship were issued. Again, see how here you will see there's a 6-day time period between when the court ordered and when I actually received letters. So just remember, you would not start your inventory and appraisal on the day of this. You're going to start it the day here. At all times, I have been acting as the conservator. So a lot of times, why would I put that, or why is it necessary? Say, for instance, I started, let's use a probate. I started as an administrator or executor. I got sick, or I was in an accident, or what have you. I couldn't complete the term. So then the court put somebody else in the place. I, as the administrator, would need to do an accounting. It wouldn't be a full year. It would only be on my term that I was administrator. So then if somebody else picked it up later, another administrator, they would start when their term was. And so at all times, nobody had to fill in, nobody had to do anything else. This is just stating I controlled the money and all of the assets the entire time. Inventory and appraisal, again, we're going to refer back. An inventory and appraisal was filed with the court on what date? That's a date you took it to court and filed it. It is not the date. Sorry, I'm moving to it. It is not the date you put here. It's the date the court stamped it right here. Okay, and at that time, the total value was 1,342,258,59. I will tell you right now that probate examiner at the courthouse is going to go, okay, 1,342. Let me go look at the inventory and appraisal. And they're going to bounce back and go, okay, the inventory and appraisal does say that. Good, we've matched there. And then they're going to switch to your accounting and go, and let me bounce up to, where is his accounting? I don't know why he doesn't put these in orders. Gonna go back here and go, okay, March 8th. What's the total? One through, everything matches. You started, you clicked, we have those boxes checked. You're in good shape, right? So exactly, now you know how to bounce and what they're looking for and where they're going to and where they're matching numbers and where they may say your inventory and appraisal doesn't match. And you're thinking, well, what the heck does that mean? I've showed you how and where they're finding their numbers. Okay, so we're going to move on to number 3, the period of account. It's not your honor, go look your own self. I'm telling him up front, I'm starting it the day I received an order, and I'm going to go the entire year. Charges and credits. Basically, what does that mean and where do you find that? Again, as you went through the accounting with Rex, charges and credits are charges, credits. So when referring to those charges and credits, that's actually what they're referring to. Sorry if I'm bouncing, and I don't mean to make you guys dizzy. I'm just trying to show you the forms and how to follow them. So your charges and credits are here. Authorized investments. So during the account period, all the cash has been in an interest-bearing account. An important thing, especially if you're a pro per, Tamara, I know you are, you must maintain the money in an interest-bearing account. It cannot just go into a checking account. It cannot just go, well, a savings account typically would be interest-bearing. It must be in an interest-bearing account. I will tell you that I have seen cases long ago, it hasn't been recent, but seen cases where there was a probate and the probate lasted, let's say, 2 years, and there was a sale of the house. There was quite a bit of money in the account, and I'll just use an example, 3 million, because there was a house sale and then the own cash. The administrator did not put it in an interest-bearing account, so none of the money gained interest for the 2 years that the probate went along. One of the beneficiaries fought and won the case, fought against the administrator, saying, now you owe me the interest that I would have received if you would have properly put the money in an interest-bearing account. And that administrator was responsible for paying for the interest out of their own pocket to cover what should have been in an interest-bearing account to those beneficiaries. So really important to make sure you put in an interest-bearing account. If you're, say, 1 or 2 months in, you haven't had it in interest-bearing account, don't panic, don't jump off the bridge or anything dramatic. Just put it in an interest-bearing account. Let it ride. Most of the time, if it's a smaller amount, what the interest would be 1 penny or 2 pennies. So nowadays, that's all they really see as far as interest. So I think you could cover a month or two if the court or somebody said you didn't have it in an interest-bearing account. But just do it as soon as possible and make sure they're in interest-bearing accounts. Okay, statement of liabilities. It should be in your accounting, but you would state that here. Next one would be, now when I start getting into these next two, say for instance, you're doing an accounting and you don't have a sale of a vehicle, then skip it, don't put it in there. All of a sudden now number 8 would be number 7. Don't write these words in here if you don't have a sale of an automobile. But then what happens? So let me tell you, I've done a few classes. Somebody, a pro per was following along. I said that. Then all of a sudden I got their petition and they're like, can you review it for me? And I'm like, yeah, sure. And not only did they skip these 2, but then they skipped some really important other ones and skipped all down to where they skipped to like here. And I was like, where the heck is all the other information? And when I asked, they said, well, you said if it didn't belong, don't put it in. I'm like, no, some stuff must be there and other stuff is discretionary. So please make sure I'm only talking about like these 2 things. I'm not talking about anything else on here. So a sale of automobile. In the accounting example we gave today, there was a sale of the automobile. So you want to tell the court, the conservator sold the automobile. It was on inventory and appraisal. Now, in our case, this would be wrong because my inventory and appraisal attachment 2, remember, non-cash did not include a vehicle. So, but in here, again, if I had a vehicle, I would have put it on there. So it says my inventory and appraisal attachment 2, line item 7, had a value. So say for instance, the value the probate referee gave was 5,000. I couldn't sell it for that because I don't know, it was missing a hood or a bumper, and I didn't tell the probate referee that. And so I could only sell it for 3,000. So I would have to indicate to the court that I had to sell it for a loss, but that I I request the judge grant me permission to have sold it for a loss and not hold me responsible. And here we have sale of furniture and fixtures. I remember in this case, I believe we sold the vacation home. So here it states it was money made from the sale of the vacation home. That was item in the inventory and appraisal. Again, it was attachment 2 because it's non-cash asset. It was item number 3. And I indicate why down here and whether I sold it for a loss or a profit. Again, sometimes you can use, especially decedents estates will use like a estate sale place or an company that does estate sales, and they will charge a percentage. You must indicate that in your petition. So basically, remember, everything you're writing here goes to all beneficiaries. And so they're also reading what you're telling the court you're doing. If they find that you're writing something here and trying to make it pretty for the judge, but you haven't really done what you've said you've done, they're going to be first to go file something at the courthouse and go, no, she didn't use I saw her out there with a garage sale. She just kept the 20% saying it was another company or something. I saw her on Facebook. She posted all of these pictures of herself or her daughter out there in the garage. So I know this isn't true. I want the 20% back, or, whatever. Remember this, what you're doing is you're indicating to all beneficiaries, I have nothing to hide, and telling the court, I have nothing to hide. So if you do something different than you report you do, a beneficiary has a right to object to it and tell the court that you're lying about it, and then they'll go from there on how they're going to correct the matter. So anyway, in this case, sold furniture and fixtures, I've indicated it here, gave plenty of reasons why. Also, in this case, we have a sale of real property. Reason being, it's the conservatee's vacation home. She's now unable to travel to that vacation home. So again, it would cost, so you're a conservator, you have to really think, it would cost me more money in property taxes, insurance. Sometimes they're in HOA places where you have to pay homeowner fees. Sometimes they'll require a gardener. You have to keep the PG&E on, maybe an internet on, maybe a telephone there. There's so much you would have to pay per month for this person's vacation home if you positively know they would never use it again. That doesn't mean keep it because, let's say the conservatee has kids that, let's say it's Tahoe, and all of her kids go and use it for to go skiing. That is not a reason to keep it. Make the conservatee pay her money to keep it functioning for the kids to be able to use it. You have to say, sorry, hun, this is the conservatee's money, and we're not keeping the vacation home. Now, if there was something that you know of, for instance, there's a trust or there's a will that says the conservatee is giving this as a gift to this person, I mean, you may have a problem with selling it or doing something like that. In that case, you may want to petition the court and ask the court, hey, I want to sell this vacation home because it's costing too much money. And the court could give you permission to do that if, or if one of the sons of the conservatee says, if you sell that vacation home that I use every year for my family trip or our family get together or family reunion, I'll have you sued in court. Then if you really want to sell it, you would ask the court for permission ahead of time, something like that. But in this case, we sold the vacation home. We're indicating it here. With let me say there's one more thing. With a conservatorship specifically, let me remind you, because this came up in a previous case of mine, you are never able to sell a home or a vacation home or any real property without court approval first. In this case, you'll see there was an order of court confirmation stating you are allowed to sell that home. Typically for a conservatorship, when you are a conservator and you do want to sell real property, whether it's a vacation home or the primary home, you do fill out an ex parte, so there's not really a hearing. That's why you'll see that this says it was filed. We have additional bond. Remember, I had asked you at one time and Tamara answered it properly. In this case, now we have more cash. We're telling the courts we sold the vacation home, so now there's a whole bunch more cash. Now our bond is not enough, and we realize it's not enough. In some cases, if it's the person's represented by an attorney, the attorney will say, hey, you better go ahead of time. We're going to have to increase your bond to cover the cash. In other cases, they may let it ride until wait for the court to say you'll have to increase your bond. So in this case, they did went ahead and increase the bond prior to the hearing. And so now the conservator is saying, I believe my bond is sufficient. Nothing in these boxes on these examples would be typed in. This is just for reference purposes. Number 11 is something, again, must go in every single petition. Must. I can't tell you. This number 11 should be starred, highlighted, everything. It must go on every petition, and it's very important for you to say whether there was an affiliate relationship during the account period. You as the conservator, did you hire a family member or somebody related to you as the conservator? I always use the quick example that I have let's say the conservator has real property. They have a landscaper they've used for, let's say, 10 years, right? The landscaper calls me up, I'm the conservator, and tells me, hey, I'm going on a 1-month vacation. Okay, great, love you, and can I go? That's my first comment. But secondly, I'm gonna go, oh God, okay, I've got to find another landscaper, right? Say it's during Christmas time, I can't find another landscaper, but my son's home from college and he's not working and not doing anything. So I tell my son, yeah, I know you're going, I know you need college money. You're going to be going back real soon, blah, 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 blah. And I state to him, the landscaper was only charging $50 every week to come mow the lawns and stuff. But since I know you need money, I'll pay you $100 a week to go mow the lawns for the next 4 weeks, blah, blah, blah. Again, I'm sure you all could see where there's a problem with that. It's fine if I say, okay, I'll pay you $50 from the conservatees money, and then I'll pay you the extra $50 from my own bank account if I wanted to. That's perfectly fine. But for me to say I'm using the conservatees money and paying you extra just because you're my son and I know you need money for college or whatever, absolutely wrong, and absolutely no. No. The other thing where I have I've seen a little bit of problem with this is, say for instance, I have a decedent's estate, so it's a probate. I have a decedent's estate and we have an administrator, and then like in one case, the administrator was a husband and the wife was a realtor. And that administrator wanted his wife to sell the property. Do you see where, and the wife determined that she wanted to charge, let's say, typically, let's see, realtor fees are 6% total. Sometimes you can get them down to 5%. But the realtor decided she wanted 3.5% and wanted to pay so she's the seller, the buyer's agent, 3%, because That's standard. So there's an extra 0.5%, and the administrator goes, yeah, okay, because I just don't want to deal with somebody else saying you're my wife. You can see where, to me, the courts will determine that that administrator did not maximize the conservatee's money, in that he okayed an extra 0.5% to his wife for, we don't even, it doesn't matter what the reason is, there's never a good reason. Now, if I flip that and say, well, my wife wants to sell it for the same fee any other realtor would sell it for, I pretty much think that's okay, as long as it would be the same fee as any other realtor would sell it for. But at least you will put it in here, the administrator's wife, who has been a professional realtor for 20 odd years and has extensive marketing and blah blah blah, and you know, she took care of it. At least you're covered, you're admitting it up front, you're describing her experience. There's nothing wrong with using her. But then again, can you see a problem where, what if I state, oh, my wife got her license just to be a realtor, just to sell this property? Well, okay, she doesn't know how to market it. She doesn't know how to get the best value. She doesn't know the ins and outs and things to really maximize that asset. The courts are going to have a little bit of a problem with you using that person as a realtor, because not only is it a family member, but they've never sold a house before. They just got their license. Are they insured? Do they know, you know, did they put it on MLS and every other marketing material thing? You just have a whole bunch of issues you run into there. So again, it's okay to hire a family member, as long as that family member is paid the same rate as the average person or any other person you could hire at this time, and you can explain that. I'll tell you one more quick other thing. I had a case where was it a conservator? I can't remember if it was a conservatorship. I think it was a decedent's estate, where the administrator, it was quite interesting. When the administrator, I was reviewing his accounting because he had many beneficiaries that were objecting to his accounting, rightfully so, because he was trying to get the approval from the court that he paid his children. Fine, okay, he paid his children, but like, he paid his children, say it was like $1,000, but one of the children were 5 years old, and the hourly rate, when I turned around and said, okay, how many hours did they work for that $1,000? And he's like 20, and I'm thinking, okay, so they were, and you know, a 6-year-old was paid $50 an hour. Like, what? Like, okay, I want that job, but no. And then his other child, which he also paid the same rate, was like 8, and then the next one was like 11 or 12, and I'm like, okay, first of all, an adult who's over the age of 18 probably couldn't get $50 to do that job, and paying a 6-year-old $50 an hour to do anything. As you know, a 6-year-old has the attention span of probably a few minutes. If you could get a half-hour work out of them, that's probably the most, if that, that you would get from them. And you can see where I was like, oh, dude, this is not gonna fly. I don't care what reasoning you give me, this is not going to fly, and you're gonna have to pay back what you paid your kids $50 an hour for. So anyway, you must disclose family relationship. Here is the conservator's compensation. Please note that we have local court rules, and I don't my pink paper here. Local court rules, yes, I do. It used to be 7.450. I'm not sure if it's still or changed, but so I can tell you the rate for a conservator's compensation is, it used to be 50 an hour for a non-professional fiduciary, and that's what you would look at it as. But as I think 2021 or 2022, I'm not sure what that date is, and again, you can look up the local court rule, but the rate changed to 75 an hour. So you cannot charge more than that, but you do not have to charge that. In this case, you will see it says that the conservator has spent over 150 hours providing services to the conservatee, who happened to be his mother. The conservator has visited the care facility at least once a week, making sure she's getting proper care, her personal needs are met. He's marshaled all the assets, he's paid all the bills, he's done this, he's done that. And in this case, for his 150 hours, he only wants to be rewarded 500. Most of the time I will see them for conservatorship, especially if it's a son taking care of mom. They will say, yeah, I don't want anything. Or if the conservatee does not have much money, asking for, again, maybe $5,000 when she has 1,000 in the bank account, like, really? You know, what is, that's not going to get you anything. And so just keep that in mind. If you're doing a probate, a decedent's estate, it's a statutory fee, so it totally different. And you must follow the statutory fee rates. And again, if you look that up, it's starts 4% of the first 100,000, then it goes 3% the next 100,000, and then it's 2% of the next 800,000. So right there, you're talking $1 million property. You would add all those together. After that, it's 1% of, I think, the next 9 million. So it covers, you know, if you get above that, I want your account. No, so there is a statutory fee that you must follow. But in this case, it would be 75. Some say, well, what constitutes my time? Just I drove to the facility to see the patient. Yes, but you could have taken them for a hair appointment. You could have taken them to get their nails done. You could have taken them. Really, I wouldn't count stuff like I took them to have coffee with me because that's my mom. I just wanted to spend time with her. Nah, that's not going to fly. I took them, or say, for instance, I had to sell all the furniture and fixtures, like I said, in a garage sale, and then I had to sell the vacation home, and I had to travel, and I had to do, you know, that's where you start adding up all your time. Say you had to fly because maybe you didn't live around here, or, you know, stuff like that, you would include that in there. Next one would be attorney compensation. Again, also, you're never allowed to pay the attorney prior to court approval unless you have something ahead of time from the court stating, for instance, you're allowed to provide like a retainer or something. And we're talking specifically for conservatorships, but also for a decedent's estate. A lot of times when you get an attorney who wants an upfront fee, as long as you have indicated that you've paid this attorney on retainer, that would be okay. But they know that they cannot get paid. So again, some people have asked me, okay, so I've paid the attorney retainer, why would I ask for compensation right now? Well, what's happened is the attorney has put that retainer money in their state Jesus, I can't think of the name right this second, but it's like their trust account, and any interest they earn off of that retainer fee goes straight back to State Bar. And so they haven't earned anything and they can't take anything. Right now, this attorney, through my words, is going to be able to withdraw $3,500 from that retainer, pay himself, and leave the rest of the money there. But the attorney does not get to collect any fees until this petition is approved. So in this case, or example we've given here, the attorney wants compensation. The attorney also must include a declaration. The attorney, in the declaration, it will need to state, and the court's very specific about it, it will need to state date, what the attorney did, and it has to be within codes. They're like separated by codes on what the attorney did. And then I even think they need to state what the purpose and then their time of what they did. So there's, you know, they need to complete a declaration. You just can't turn it in. You'll see in this case, he's listed this as Exhibit A and wants fees. So if you don't have an attorney, you're just proper, again, you wouldn't put it in because you don't have an attorney. Okay, we're gonna keep going. Veterans benefits, we're at our 12 o'clock. Veterans benefits, it is really important to state on here whether the conservatee is receiving veteran benefits or not. In most cases, the ones I've completed myself, I have not had one, but it's really important to tell the courts that, and it's really important to state whether the conservatee is like combined to a state hospital, not just a regular hospital, but a state hospital. You must state that also in there. Number 16 puts the conservatee's address. Usually if they're in a care home or a facility, I don't mind stating the actual address or where the conservatee is. If the conservatee is, let's say, at home and doesn't, well, there's two things that I take into consideration is if the conservatee is at their own home, more than likely the court wouldn't issue you to be a conservator, because if the person's able to take care of themselves at their own home, there's no reason to take their rights away from them. But say still the conservatee is at home and maybe I live in the home with them, let's say. I'm not necessarily comfortable with providing the home address and saying, oh yeah, we're at home. Come do whatever you want. I may just say the conservatee is living at her primary residence and I'm here also, or, you know, whatever. So next would be account statements. Remember that when you're doing accounting, and I do remind ProPERS this all the time, you must submit the bank statements when you're doing the accounting. They must be original bank statements. Original bank statements do not mean you printed them off the internet. You there's two ways to do it. Either when you set up the account, you tell the bank you need the originals mailed to you every single month, or in some other cases with some of my conservatorships, they have online access. I have to tell them they have to go to the bank and you have to ask the bank to print out a bank statement, and then the bank must use their stamp and put a stamp on it to certify it is original bank statement, and then you submit that to the court. If you do try to submit just a printed off the internet type of bank statement, the courts will reject it and state you haven't provided provided original bank statement. So you will see here that I've stating that I'm submitting the bank statements to the court. There is, and I don't know if Rex went through this with you, there is a separate cover sheet that you, when you submit your bank statements to the court, the cover sheet, and did he show it to you? Do you guys remember? Okay, perfect. So that cover sheet you use is separate. It's not filed with this. It doesn't become public record. And so therefore the, it's separate, but you do state you've submitted the original bank statements. So capital changes. Yes, hon, go ahead. Karina, sorry, you had a question?
Sorry, it was, yes, but it was freezing. For the bank statements, is that also for probate cases or just conservatorships?
Probate cases also, honey.
Oh,
Original bank statements, always.
okay.
Unless, like I said, say for instance, your decedent's estate just wants to do online access, you know, you still, when you're gonna submit your accounting to the court or to your beneficiaries, when not to your beneficiaries, because you don't ever send them bank statements, but when you're going to submit to the court your petition, which includes an accounting, you do a separate cover sheet for your original bank statements. And then if you have to, you ask the administrator to, or the executor, if it's will annexed or whatever, or will, you ask them to go to the bank and have the bank print the statements and then certify them.
Okay. Thank you.
The only thing I don't like about that is, and let me tell you, like, one of my clients, I think it's Travis Credit Union, and he went and had, it was a 2-year conservatorship accounting, and he went to the bank to ask the bank to reprint the bank statements, and I think they ended up charging him like almost $400, and I was like, dude, what? Like, how in the hell are you gonna explain that to the court? You spend $400 reprinting bank statement. You need to immediately screw the online access. You need to get those, or ask the bank to do online and mail every single month your original statements and keep them. So I would do it that way. So
And I can't try to charge us $300 for a case. Somebody that that decedent hadn't paid taxes in 25 years, so we needed their bank statements like from very, very far, and they wanted about 300.
yeah, it's wild, right? So yes, if you need to do stuff like that, I'm sorry, and I hate that, because but you have to realize, like, a lot of times, especially with a decedent's estate, they may not have kept their bank records, so you have to go back and get them. But when you're doing a conservatorship, or when you're doing a decedent's estate now, and you take control of those banks, it is up to you to indicate to the bank itself, I must have original bank statements because I have to turn them in. So yes, again, you have two choices: have the bank do it. If they don't charge, that's great. Then maybe you don't want the papers to come every month, but if they do charge, yes, make sure you just say, because it's funny. So if you get them mailed to you every month, there's typically not a charge, but if you want them to print it, oh yeah, they're paying a charge, right?
Makes no sense.
None. So, okay, capital changes. I'm telling the court if there was any capital changes, statement of liabilities in this case, whether there's a promissory note or not on the property. So it looks like in this case, remember we had 2 properties. We had a vacation home and a primary home. It looks like that there is a a promissory note on the first primary residence. So you would state what that balance is. Again, you're being upfront. A lot of times where this states how much interest or what the interest percentage rate is, sometimes I don't even know that. And I will just say the monthly payments are this amount and not leave this in because I just can't figure it out. And I really don't include most of the time whether there's a big balloon payment at the end. I just don't for an accounting, maybe on a sale or something, but not in accounting, but that's up to you whether you want to include that or not. Special notice, for people who do work in the law firm or those who don't, you may receive what's called a request for special notice. What does that mean? Anybody, and I'm talking anybody, I myself can go down as long as I have a bunch of $40 checks, right? I can go to the courthouse and for $40, I can file what's called a request for special notice, and I can make sure that every single document that's filed on this case, I get a copy of that document when it's filed. A lot of times people who are doing the request for special notices, let's say the inheritance advance sharks, they drive me nuts. I mean, really, I think it's total scam, but that's my own personal opinion about them, but not anything else. So a lot of times the beneficiaries don't want to wait for their money, so there's an opportunity for them to get an inheritance advance. Most of the time, and why do I think they're a scam? Most of the time the inheritance advance companies, and if they're watching this video, sorry, I'm being so mean about it, but what they'll do is they'll tell the beneficiary, oh yeah, so they'll say, I'll give you $5,000 cash right now. I'll give you $5,000 cash right now. And if you pay it back in, let's say 90 days, you only have to pay me, let's say 40% or 25%. And then if it goes 120 days, you have to pay me, 50%. And then it goes up. And I will tell you that a probate, I don't think I've ever seen a probate case that settles completely in distribution unless it's extremely simple, in less than at least a year and a half. And so people don't realize it takes that long, and so most of the time you're ending up paying double. So to get 5,000 now, you're giving up 10,000 of your inheritance just to borrow the money now, because they've made you think, oh, I only have to pay back 50%. Okay, that's not that much. I'll get the cash now. But then don't realize it's double what you borrowed most of the time. And I just don't like them. So anyway, they're usually the ones that file a request for special notice. Sometimes, let's see, in a decedent's estate, I'll see that somebody who isn't related to an estate filed this, and the reason being, let's say a cousin or somebody else who just, I don't know, thinks maybe somehow, some way they might get something, they can do a request for special notice. The other way I've seen it, where there's cases in a probate where one attorney has started the case, and then say they represent a son or daughter, but then another attorney has come in because you have a surviving spouse. Surviving spouse takes priority, so they file a competing petition. And then when that's the case, the second attorney actually gets the probate. And so the first attorney will go, wait, I filed first and I want to be paid some. So they will file a request for special notice, and they may contact the law firm and say, hey, I kind of filed first. Can I get a little little bit of the fee that you're paid, and you can work things out that way. But that's typically all I see on the request for special notice. Okay, we're getting down to the very end. So we're at the end. We've stated everything that happened during the account period. And now what do we want the judge to do? Basically, the front information was, okay, judge, this is in court, and anybody beneficiaries, this is what I did. Now, what do I want the court to do? So this is what I want the court to do. So I actually, as the conservator, am praying to the court that they approve my and settle my count and report. Keep in mind, a lot of times people ask me, well, why do I care? Okay, so once the court has approved your accounting and says it's good or good enough for the court approval, a beneficiary, it limits the liability of the conservator, of the administrator, of the executor, of the guardian, of the, I could keep on going, whatever reason you're doing this for. So really what happens is once the court approves and settles it, it's very difficult and going to be very, very difficult for a beneficiary to come back and litigate against you later and say, hey, wait a minute, that accounting she did 4 years ago, it was wrong and she lied or whatever. The court's going to go, no, you had your time. You never said anything then. It's approved. We settled it. Moving on. So it really limits the liability. What that means then also is the beneficiaries only have a certain amount of time period to object the accounting that's turned in and indicate to the court where they feel something was done wrong, maybe misappropriated, or something they don't feel was done proper. That's their time to say something then. Okay, so what else do I want? I want all acts that I did to be approved, meaning selling of the car, selling the vacation home. You get that. But in this case, I'm going to, for those specific things, we'll indicate them separately. So this is in addition to what I did in the accounting. Approve the sale of the vehicle, even though you realize it was a depreciated asset. The furniture. Then upon the settlement of this account, so upon your approval, Your Honor, please allow me to pay myself the $500 I asked for above as compensation during the account period. Now I can't take any more. Like once I ask for that amount, I better be satisfied with it because I won't get any more until the next time I file an accounting, which would be 2 years. For a probate, you only file an accounting typically once. But you still, as a probate, you can't ask for compensation. So no matter how many times you file an accounting. In this case, again, we had an attorney. So upon the settlement of this account, please allow me to pay the attorney his fees because they are to date unpaid. And I always include this. Anything else the court feels is proper to approve and whatever they want. This allows them to add, to include whatever they want. They would anyway, but it's just kind of like a respectful thing to add on there at the end. Then you will date it. And as a pro per, well, there's one more thing that I do like to also add in if it's just done by a pro per. So if a pro per is completing this, because well, let me go on first and I'll come back to this. So I will add one more line item here, which I'll explain what it is in just a minute. So again, date it, sign it as the conservator. Now, this form looks a little bit different than how I would prepare it if an attorney was preparing it. If an attorney was preparing this form, which they would if there was an attorney handling the case, the conservator would not fill out this himself and then go, here, attorney, sign this for me. No, it doesn't work that way. So what would happen is this attorney information I would put here, and then you will see on a next page, there has to be a verification. Now, I will tell you that it's so funny that how many times that, especially from Contra Costa, that I have had people contact me and say, Tamara, I don't get what the court is saying. They just keep saying, I need a verified deck. And literally that's how they write it. You haven't included a verified deck, or you need to include a verified deck, or you don't have a verified deck. And they're like, I don't even get what the heck that means. Let me show you what that means. This page right here. You must include this, especially if you're a law firm or attorney, putting this on any petition, any motion, anything you submit to the court, that it is a verification that you are the conservator. And really all the court wants to see is this one line, this one line, sorry, it keeps highlighting more, but true and correct, that you declare under penalty of perjury. So now say that I'm a pro per, and I wouldn't necessarily do a verified deck because this is my own writing anyway. I will always include this last line right here. I will always include it right here that says, I declare under penalty of perjury, this information is true and correct, blah, blah, blah. And let's pretend there's no attorney and only this person is signing. I will include those words here, and then just have the conservator sign and fill that out. Again, if it's being filled out by an attorney, there must be a verification that this person, the conservator, is the one that provided the information to the attorney to complete this petition, and that everything they stated was true and correct under the laws of the state of California. And if something is found out to be incorrect and how do you say, they purposefully lied or did something else, then the court has the ability to issue sanctions on it. And then, oh, here's the original bank statement document. So now we have completed the entire petition for the approval of accounting. Are there any questions? No, you guys are good? All
I think
good?
Jan had a comment in the comments in the chats.
Okay, go for it.
Well, she mentioned and said that for probate, there is no requirement that you submit original bank statements. The probate code section 2620 does not apply to probate of an estate. Is that true?
Jan, for probate, there was no requirement to submit the original bank statements. That's interesting. Well, there might not be actually a requirement, but I will tell you, even for probate, try submitting a petition to the examiners, Erica, Linda Saponish, or I forgot the other new girl's name. Forgot her name escapes me, and they will tell you they want original bank statements. So maybe it's best that, depending upon the court that you were filing with, that you ask the probate referees, or probate referees, probate examiners, or based on how many times or what you file, whether they request original bank statements or not. I know Alameda can be a little bit pickier, not a little bit, a whole lot pickier than many other counties. San Francisco, oh my gosh, to me, San Francisco is almost impossible to get anything through. But then I know a lot of people who like working San Francisco, so or work San Francisco County. So again, just verify with your probate referees, probate examiners, whether original bank statements are not due or not with it. That's nice that they're not. Are there any other questions? Now, again, Rex does state he puts this up on his YouTube channel. I don't know much about that. And again, he hasn't included, like, I think he's given all his contact information if you wish to contact him. Again, he's a CPA, he's an attorney, he does have his contact information. He doesn't provide my contact information. So I separately am an LDA. I do help him with cases, but I probably have 10 or 11 other attorneys that I provide paralegal and or LDA work for. I do many accountings from down south, Southern California, to all the way up north in Redding and other areas. And so I have experience, and typically if I can't figure it out, I'm calling again the examiners asking, okay, I've done everything I could think of, I can't. I want to state that when I was doing an accounting for a conservatorship the other day, believe it or not, and it's the first time that happened, I was 3 cents off. And I couldn't find that damn 3 cents to save my life. And it's like, okay, I can spend, because I'm billing out already, obviously. I can spend, I don't know, 10 more hours looking for this 3 cents, or I can just write an adjustment and say, I honestly cannot find this 3 cents. I mean, I could tape 3 cents to the accounting and go, I just don't want to look for it anymore. I'll give it to you, court, to give it back. I don't know. So there might be something like that. If it was more money than that I couldn't find, or that, I couldn't reconcile, yes, I would spend the time to make sure, because you do want it right. But then again, keep in mind, if I'm billing an hourly rate, is it worth trying to find the $1.23 or even the 3 cents? In my case, no, it would not be worth it to sit there and spend more time trying to find it. All I would do in that case would give it back and say, I've exhausted everything I could. My suggestion might be that you just do an adjustment and explain in the accounting to the court that you made the adjustment because you really did your best to look for this 3 cents and you just couldn't find it. Most of the time the courts will accept that and just kind of move on. So again, I have a website. It's Cal Legal Docs, which is just CA and then the word legal and then DOCS.com. And that would provide my contact information. So if there's any, and I do tell this to if there's anybody who wishes, or they just can't get something approved and they just want me to glance at something, if it's a quick and I'd say up to 30 minutes where I'm just kind of glancing, or what's this, or should I include this, or what should I do with this? And it's a quick answer. I absolutely would do it for free and just help you there. You don't have to worry about it. If it's something that requires me 2 or 3 hours to go into it, I would say, okay, I can't do this. And you know, we could work out something else. But most of the time, if it's coming from law firms or somebody else, I just have a quick question. Although, if you know, that's never a quick answer. You have a quick question, but the answer is not really quick. So you are free to ask me quick questions or help, or have you ever seen this before, or what do you think I should do with this? And I'm able to help. And then again, you know, I suggest, especially if you are working for a firm, if, you know, sometimes if you ever hear of somebody outside of your job who really just needs help, and, you know, try and help them, and just say, be careful about giving legal advice and not doing that, but just saying, okay, what are you trying to do? What are you trying to help? And then again, remember, if you have any friends who also are doing this, that can't afford an attorney, that wish to watch the accounting class, suggest it. It's through the Contra Costa County Superior Court. It was initially approved by Judge Sugiyama, who was our judge a few years ago, but it is also approved by Virginia George and Finstermacher, who now runs probate in Contra Costa County. But it doesn't matter if your case is not in Contra Costa County, your case can be down south, Alameda, anywhere else. They can always sign on, or they can always review the recording. But otherwise, we're at 12:30. We're ready to go. It's lunchtime, right? Coffee's done, lunchtime. I see Tamara over there. Yes, let's eat. So thank you guys. I wish you, anytime you want to come for any other class, it's up to you. You can come as many times as you want. You can hear us talk as much as you want. Otherwise, I wish you all a great day, and thank you. And hope all goes well with your accountings.
Bye.
Thank you.
Bye, guys. Thanks.